We'll call the meeting to order and turn it over to Brad to introduce the task force, which, by the way, we thank greatly for all the efforts they have made, time and effort they put into doing all of it, get it to a point where hopefully we can get some decisions made. So thank you.
I'm just going to probably step up there just because I think it may make it easier. My name is Brad McElwain. I'm a board member and the secretary, but I've also been the chair of the governance task force. Amanda Mole, who was developers rep, is also on the board. She was also on the task force with us. And if you want to say anything, I'm going to let all the task force members say something, but I would like to say I shared Jerry's thanks. I mean, this was a group that worked incredibly hard. A lot of our committees, and it's not a slight against our committees, they think of things, but they don't actually execute on what they do. This group both thought of things and executed. It was they thought of what needed to be done and then went and drafted it and saved the community a lot of money. I think we've got a great product. We've gotten the expertise, and you'll hear from the various members the expertise that we've had. And I think it's created something that's a great product for the community with a lot of really thoughtful insight into what needed to be in these in our governing documents. And just for a quick thing is we are only dealing with the bylaws today because I thought that was probably the most, it seemed to be an area where there was the most issue, I'm not saying issues, but questions. And I thought it would be helpful to go through that. And that's probably a full meeting. So Amanda, if you want to say anything, or are you joking?
No, it's been a good experience from the perspective that we've all shared our thoughts, and I'm looking forward to today being a productive meeting where we all have a chance to fully vet what has been presented and hopefully reach some consensus.
So Kelly, can you introduce yourself?
Yes, do you want me to turn around?
If you can, that'd be great.
I'm not even on there.
You're not even on there. Sit out here.
Here. Yeah, stand about where more. I'm not a lawyer. I'm a CPA, and I worked for PricewaterhouseCoopers as an auditor for 10 years. And then I went abroad for 20 years with my husband, he's the finance director. And then we came back here in 16. So I've been here a few years, so I just wanted to get involved and give a different perspective than lawyers.
At 425 Sea Lander Court. My wife Debbie and I first came to Kiel about 1986, I guess the first time, and we bought our place about 10 years ago. My career was spent primarily in real estate development, which is, I think, maybe once run below lawyers on the internet or wherever. And in that, I was involved in a number of commercial and mixed-use residential condominium creations. And also was on the board of 2 HOAs, even though they were small, so I've had that experience as well. But I thank the board for spending the time as well to review this. It's a difficult process. I appreciate all of you giving it your full attention. And I thank the committee and my fellow committee members. It was a good experience. Thank you.
Out. She was a person. She kept her words down and kept paring things down to make it simple. She's very cool. And I am a lawyer, so I'm a licensed lawyer in the state of South Carolina. I spent 30 years at the Environmental Protection Agency. I worked on regulatory issues. I rewrote regs. I rewrote statutes. I interpreted them. So I had a lot of background experience in that. Prior to law school, I was a water quality biologist working at DHEC in South Carolina. So I've had a lot of various experiences here. Like everybody else, I really appreciate the opportunity to be on this committee. I think we worked well together. We had a lot of good opinions, different opinions, and we tried to really condense what had to be done into what needed to be done. As you can see, I'm one arm down. The last few days, I've been taking with one finger, which is nothing pleasant, but we've gotten through all this. Once again, thanks everybody on the board, and hope you have a good day.
Your broken arm is not related to the committee though, right?
I mean, I won't tell you who on this committee broke my arm.
He got hit by a car at the intersection of Buckle and Flatwood.
So, and in my prior life, I was a lawyer too for more than 30 years. So I did mostly construction, although I did a little business. With that, I think we will start up. The process that I wanted to go through today is we kind of divided things up into big topics based on the comments that we got. We got over 60 comments through the portal, which I thought was a really great. I wasn't expecting that many, and I thought it was great that we got that many. So what we tried to do is divide up the comments into topics, and we're going to go through a topic and kind of go summarize some of the comments. And then after each topic, I thought I'd open it up to any board comments and then any community comments, and then we'll go to the next then we'll deal with each topic sort of as is. So that's the way I propose to do it. So anyway, we talked about the members of the task force. Shannon also participated. She was in every meeting. They were, and that's a big deal because these were long meetings. They were generally 3 hours long. And Ellen too. Ellen even did it on her birthday, which was probably more than,
Special.
very special. So, so it was, these were long meetings and they were at times tedious because the drafting by committee is a tedious process, but it's an important process. And I think it's important to understand that we did this basically by consensus. We tried to incorporate everybody's comments on the task force and reach a consensus on what the documents are. So they are a consensus document. So it's, each person may have had slightly different views, but we tried to reach a decision where the language, everybody was comfortable with the language that we were using. I don't know if you can. This is just so that everybody understands what we were supposed to do. It's not that exciting, but it is our mandate. It's what every committee has a charter. This was the mandate out of our charter. This is specifically what it was. We were to look at the bylaws and make covenants and bylaws and make recommendations. We were also talking about how to communicate this. This meeting is part of that effort on how to communicate. We were to hire counsel, which we did. And originally we were allowed up to $25,000. We then came back at one point and asked for an additional $15,000, which the board unanimously granted. So anyway, on 2022, we realized that everybody, I think, understands that changing the covenants is a bigger deal because it requires a vote of the membership, and it's a fairly high threshold for the vote of the membership. It can be done, it's not impossible, but it's more difficult. So our efforts were focused on the bylaws, where we thought it is the one thing that the board does control, and it's day-to-day things. We will hopefully at some point make recommendations on covenants. As I noted, we operated based on consensus. The law firm that we chose was Rose and Haygood. We chose them. They had worked with KICA. And so they were somewhat familiar with our governing documents. They also represented other HOAs in the area, so they were familiar with HOA requirements. They also, and most importantly, didn't have any current connections with any major stakeholder on the island, which we thought was important. We didn't want a law firm that had a tie to the partners or the resort or any significant stakeholder, and they did not. Timeline, we kicked this all off basically on April 4th. The members were selected, approved by the board. We met all through 2022. I kept, if you listened to or attended the board meetings, you understood that I kept saying what we were doing. And one of the things we were talking about was compliance with the law and covenants, minimizing private meetings, addressing conflicts, and a one-year term for all board members. That came up several times. On December 5th, announced that the draft documents would be presented at our meeting on December 5th, announced that the draft documents would be presented in February with a 30-day period for review and possible town hall meeting to discuss changes. This is the town hall meeting. January 9th, board unanimously agreed, approves an extra 15,000. January 2023, what happened was after we had drafted the bylaws, come up with the draft, we went to Rosenhagood and presented them to them and said, please look at them. Do you have any suggestions? And most importantly, do you think that there's any problem with legality of any of this? Does it comply with the law? Does it comply with our covenants? And then finally, on February 8th, the draft bylaws and governance procedure manuals were provided to members for review. We had meetings of the governance task force. We had a public meeting where we considered the approximately 40 comments that were received to date and went through them. We've now had subsequent meetings on February 24th and 7th to address the concerns or comments that we did. Today, we're having a town hall workshop and to discuss that. And then we go to the next. We've maintained, I mean, one of the things, the most important things I think that we did is to ensure compliance with South Carolina law, applicable court opinions and decisions in the covenants. Right? To me, this was a problem. We had a problem. Our current bylaws have a problem. They don't comply with South Carolina law in some instances. We don't believe, or at least there's a question whether they comply with applicable court opinions. And they at times didn't even seem to really go with the covenants. So this one obviously was task number one. We also wanted to improve clarity and reduce ambiguity. Anybody who's dealt with our bylaws knows that they're not exactly clear at times. They're also sometimes, you know, we've had issues where we can't quite figure out what's going on. So the idea was, let's put that in and make it clear. Limit private meetings by the board. And this is something that I've noticed through my 3 years, but it also, and I've said this before, when I became a board member, I met with the major stakeholders on the island. And one of those was I met with Craig Weaver, who was then mayor of the town. And Craig had also been board chair of KICA. And he had said to me, he said, you know, one of the biggest problems he sees with KICA as it existed at that point, he said, is that it does things in private and people just don't trust it when it trusts things in private. He said, I'm not saying anything's wrong, but he said it just, it hurts your credibility unless you do it in public. And he said, I understand that KICA isn't subject to the open records or public meeting requirements that, for example, the town is, but he said, you really ought to try to follow those as much as you can. And that's what we tried to do when we revised the bylaws. I thought Craig's points were valid. I've seen that throughout my tenure as a board member, that when we do things in private, it looks bad and people or members don't trust it. It may be for completely correct reasons, but it looks bad. And the best way to do it is just do it in public. The fourth one was provide procedures allowed by the covenants and bylaws. We had certain things where it said you could do it, but didn't say how you could do it. And that became a real problem. It's a problem for the board. It's a problem for staff. It's a problem for our members. For example, when we had tried to do the petition, when there was a petition done with respect to the appointment issue, how you did it wasn't spelled out. And that became a source of conflict. I mean, there's enough conflict when you're going through a petition, but having to discuss and trying to resolve things about how you actually do it creates more issues. The fifth one was try to address issues which have arisen over the past and reduce conflict. We've seen this over the past several years, there's been a lot of conflict on the board. And one of the things was, can we do things, put things in the bylaws, which will hopefully force the board to actually speak to one another. One of the things I've seen is that, you get a fourth, you get the majority having 4, and that's the end of the discussion. So what we try provision that deals with conflict of interest, but it specifically notes it's a floor, but not you can add additional requirements, which we have done in these bylaws, because we saw issues where there were particular problems. So with that, I'd like to just go over a little bit. We talk about compliance with the law. What is the law? There are 2 primary statutes that govern KICA. The first one is the Nonprofit Corporations Act, and the second one is the Homeowner Associations Act. The HOA Act is, it had started, my understanding is it started off in the legislature as a very broad act and got basically chopped down significantly, so that all it really says at this point is it talks about that you have to record your documents in order to be effective. It says a few other things, but that's the primary thing. Our main focus was the Nonprofit Corporation Act, because that's the primary statute that defines our legal obligations, because we are a nonprofit corporation. And what you'll find is the act is helpful, but it also, because it deals with all nonprofits, some of the stuff is applicable, some of it's not. We had to deal with where it may be issues that it's not necessarily the same as an HOA. And I think what we talked about in the cover memo when we sent out, the Nonprofit Corporation Act has really 3 things. It says some things are mandatory, some things are the things that you can that they're the default unless your covenants or bylaws say otherwise. And the third thing is it establishes a floor. So you need at least this, but you can add certain things on top of it. So when we go through this, we can talk about some of these things. Some of the questions that have come up are things that are actually mandatory in the statute. And so we can talk about whether we like them or disagree with them, but we really don't have a choice. And so the question on that is, we just comply. And so that's basically South Carolina law, except I wanted to go through one of the next slide we can now. This comes through, and this is a critical point that will go through all the bylaws. The legal power and duty, because there's been some question about what does the board really do? And what is the board's obligation? And the Nonprofit Act is very clear on what the board does. And I've quoted it here because I think it is important for everyone to understand. It's out of Section 801. All corporate powers must be exercised by or under the authority of, and the affairs of the corporation managed under the direction of the board. Basically, the board controls all. The board is responsible for the entire, all of KICA. And therefore, we drafted the bylaws and governance procedures manual to comply with this legal mandate. All right. Just wanted to say some general concepts. These are just kind of drafting concepts, and this is probably more for the lawyers that they probably recognize some of this. But generally, the thought is when you're drafting something that you say it only once to avoid potential ambiguity or conflicts. One of the things you'll see that got deleted from the draft bylaws is there was a huge section that talked about type A, type B, type A, and whatever in our bylaws. That's already in our covenants, and our covenants govern. So the question is, why do we say it again? So you'll see it just got deleted. It's not because it's not important, it's because it's already been said once and we didn't want to say it again. One of the things too, just to understand, South Carolina, almost all HOAs, including ours, are modeled after the Sea Pines bylaws, because Sea Pines was the original HOA in the state of South Carolina. So everybody cribbed off of what Sea Pines had done. What we did is, that provided us with a helpful tool, because then we could look at what other HOAs had done who had started off with sea pines and see was there a good model that we could use that would help us. And Jim had come up with and found the Hilton Head Plantation bylaws as a model. And they were originally out of sea pines, but they were much simplified. I mean, one of the things, for example, that you'll see in ours, we have a definition section, which is right up front. I mean, that's generally considered a good drafting procedure. We didn't have that. We don't have that in our bylaws. There are definitions in our bylaws, current bylaws, but they're interspersed. They're you got to kind of search through to try to figure out if it's defined. And sometimes it's not actually defined. You go through and try to figure out where is this term defined and end up finding it's never defined. So you'll see one of the things that we have in the draft bylaws is all definitions are up front unless they're only used once. And if they're used once, then sometimes we did that. With those things in mind, I'd like to go through the comments. First one was ensure compliance with South Carolina law, applicable court opinions and decisions and the covenants. This one seems to be pretty straightforward, and no commenter that we heard from took issue with the goal. I mean, it's a pretty, I think it would be hard to say, let's not comply with the law. There was some disagreement over the scope of the 2021 court decision of addressing the board appointments. And the task force took the position that if there was an action where there was a question about its legality and an action and compared to that, there was an action that was clearly legal, it would choose the clearly legal option. I mean, for example, there is a question about appointments. I mean, certain people believe, I'm one of them, that the court decision basically said no appointments. And the reason the court decision, the basis for that court decision is our covenants. Our covenants say all board members but we are not, we haven't changed the covenants. So we have that restriction that all board members have to be elected. Now, some people have argued, well, maybe it doesn't extend to certain circumstances. And those are valid, you know, people can have that opinion. But when it's a question where somebody believes one thing and somebody believes other things, and they're both reasonable people, we took the position that we should do what's clearly legal. It's something that I've taken the position throughout my time on the board. As a community association, we should be doing things where we're not in question. It's particularly on legality. That, you know, we can take issues as, but if it's whether we can do it or not, we need to be strictly standing on the side of legality. And there's an old adage in the law that if you're close enough to the line where you have to think about it, you're already gone too far. And I think that's where we are. If you're thinking about whether it's legal or not, we don't want to be there. We'll take the clearly legal. And if you want to change it, for example, if you want to go to something else as far as appointments, go change the bylaws. And if the members agree to that, the members agree to that. Covenants, sorry about that, yes. So anyway, so what I was going to do after each topic, just open it up, and if there's any comments from the board on that, and then any comments from members. I'm not sure there will be on this one.
Are we finished with the first one?
Yes.
Is that what you're saying?
Yeah.
Okay, so I've got a question on that. Ella, can you go back one page, please? Can you guys summarize for us where in the current bylaws we weren't in compliance with South Carolina law? Is that a thing that's easy to do or hard to do?
Sure. I can start off, and Jim, I mean, one of them, for example, is the record date. We have been choosing a record date for our basically our elections that's more than 70 days. The act requires a record date of no more than 70 days before the election. There are other issues where
There are issues about member rights with respect to good standing and how you can address different processes if a member violates the rules, what the rights of that member are that were not incorporated in our bylaws.
We had,
Would it be better if we had, obviously, Lisa has an interest in that specifically, and I don't know if other board members do, but they would just create a separate document that specifies all those things.
I
That'd be
mean,
great.
one of the
We
things.
have other documents that we've been working on that do different things, and it wouldn't be hard for us to
Yeah,
outline.
I just think, I mean, that's useful, right? I think that'd be great.
Membership lists, for one example, Shannon knows that we have not properly compiled membership lists and made them available as per the statute. So I'm still on definition, so I think.
That's fine, it'd be great.
Go through, yeah, okay.
One of the issues too is that we changed the threshold for a special meeting, and we changed it, didn't we?
Well, there was really no threshold in there.
And we
Threshold is
put
statutory.
the statutory one.
Yeah, if there's, opportunity to do that, I think that would be great. Then we
We've been
can.
working on that document, but we haven't had a chance as a committee to go through the document.
Great. That'd be great, really
Just so
helpful.
you know, there's a couple of documents that are in flux. One is a crosswalk that lays out the newest version, the newest edited version of the
That
bylaws.
was provided to the board last night.
Provided it, yeah, did the board get that last night? Okay, and then the other one was the statutory reference, because people were complaining that it's a very lengthy document.
What was the crosswalk?
I didn't get a crosswalk.
No.
They
No, I
didn't
sent it
get-
to Shannon.
They didn't get a crosswalk.
Okay.
They only got the red lines.
I sent it to Shannon last night. What it does is it says green line on one side of the most recent version. And then on one side has the existing bylaws side by side, so you can see what the existing bylaws said and what our newest version said. We were hesitant because it's 40-something pages long, which just is the nature of the comparison that's done. The other document that is out there that can be shared is, I know there was concern about having to keep going back to the statute and see what the statute said. Well, what I did was excerpted every piece of the statute that is cited in any part of the bylaws, reference the bylaw with the language of the statute, so you can just look at it easily.
This is a problem, because I actually did send it out last night to the board. I don't know what happened to it.
Well, I sent it to the message I
Yeah,
sent.
but I sent it to the board last night. And
Okay.
Okay, but the committee as a whole hasn't reviewed it, even though I feel you did so much work on it. Yeah, left-handed. So I just think that's a whole subject that we probably should have another board. The committee meets first, talks about it, and then the board and the committee can discuss it again.
Anyway, so,
So we could do just as on my one point, if we could do here's what the law says, here's where we didn't comply or comport, that would be great.
And I didn't get anything from you last night.
yeah, I looked, something happened. I sent it to board, but for whatever reason, it didn't go through. I don't know why.
I always get a board plus members.
Yeah, you have to be careful.
Understand.
Yeah, and I don't know.
I don't know what that is.
There's
Neither.
there's an email, so that doesn't work.
Yeah, I think I used that one.
It says email, it says board plus members.
Members, and
And it
I go,
doesn't,
oh, I don't.
When I sent something to the board,
Board plus
these
equals
problems,
Y.
I have that little thing on there and it scares me.
there's a bad one there.
If we could do that,
The South Carolina law comparison.
Yeah.
And I'll send Phil's crosswalk from last night out as well.
I think Kelly said she was.
Oh, she wants to see it.
Do it.
I think we should, as a committee, just have one meeting to talk with crosswalk.
It's already out there, a couple.
Yeah, I don't send.
It's not, there's editorial stuff in there.
Anyway, the second comment was, I assume there wasn't. We have any public comments? I assume we didn't.
I don't see any raised hands.
Okay. All right, second one was improved clarity and ambiguity. This was one where we did get a fair number of comments, and these were actually helpful because obviously if we're trying to improve clarity and reduce ambiguity, if people have We try to do that as we've worked our way through, so that the latest draft deals with some of the issues. For example, the petition one, people found it confusing. And so we tried to revise it to make it clearer as to how the process actually works. Some other things where we added, there were questions about on the conflicts. There was an issue about the arbitration clause and how that worked. We beefed that up and so that it's clear how it actually works. So the process, again, making the process.
Brad, if we have time today, one of the things I would hope we could do, at least it would be helpful to me, is to be able to kind of walk through the process, starting with a petition to a referendum to when is a special meeting.
Yeah,
And understand that and understand the percentages you're recommending and the implications. Your second draft made it easier, but it's still a little confusing.
Foreshadowing.
Yeah. Limit private meetings by the board. Raised objections to this goal, although one board member requested the board to be able to determine what private meetings are private. The only member comments we got on this issue were that we actually not made it tight enough, that we needed to tighten up some of the definitions. The exceptions that we use for executive sessions are basically those that are in the state act that all governments have to comply with. I mean, they're the standard ones: HR, receiving legal advice, but they're all types of things that are the standard exceptions. And so we thought, again, trying to keep ourselves as close as we can to what the town does. There is one significant difference, and this was a question that did come up. The town has specific restrictions on who can meet. For example, you cannot have, you'll see that they don't want to meet more than 2 of them at a time because they think it will become a meeting and therefore has to be public. There is nothing in the bylaws like that. There's no restriction on who, you know, all 5 of you could meet or 7 of you could meet. But so you don't have to do the 2 by 2s because that's when it becomes cumbersome. And we just basically took the position that the board cannot conduct business, which is essentially take votes in private, except for certain circumstances.
Which is different than also the town is not permitted at all in executive session to take votes. In the case of the way we drafted it here, you can still take votes on those issues in executive session. So there are some key differences in terms of giving you more flexibility than a public entity would have. Or in terms of the meetings and what actions you can take in a private meeting.
Could you define what allowed executive session means?
It's in the bylaw. And
List of things that are defined.
So it's not a number.
no.
It's topic driven versus.
Yeah.
Okay.
So are we supposed to ask questions along the way? Or are you?
Yes,
moving
you
to-
ask questions now.
So I still have a question on this one for executive sessions, and I know, Brad, we went back and forth on this. I understand what you're trying to do and why. I think there's going to be just a little bit of practicality with it. And I think the board somehow should have some judgment to be able to add a topic so it's not so restrictive. And, you know, I had asked for another sentence and Brad had explained why you guys thought that wasn't appropriate because it kind of opens the whole thing up and makes, in Beth's words, makes the rest of them kind of void. But I still think from a practicality perspective, the board needs a little judgment there. And so if we're going to be held to that specific rigidity in the bylaws, how is that judgment ever going to get executed?
Well, I think A through F in and of themselves has some subjectivity. I mean, I think that's the answer I would give you. If you look at A through F, you know, obviously you're using words to describe them is going to create some level of subjectivity. So I can't think of any, I mean, we went over this with Shannon in particular, the history of what of items that that the board would typically want to discuss in executive session. And we work these things pretty difficult, in particular.
And for the board, they're on page 14 of the. red
Yeah,
line.
I'm sorry, page 14, under section 7.
And he's looking at this second paragraph.
Right. Well, I think there's a fair amount of subjectivity just within those that the board has, can make it, it's up to the board to make a determination whether they believe the subject is within these items.
My experience in 4 years on the board, than what's listed in section 7, I don't recall discussing anything that couldn't be done in public. And if you have an exception to the executive session, legally, basically the new rule eats the rule. As soon as you say for another reason, throw the rule out the window. Doesn't mean anything. We can decide, well, we want to do this in executive session. And that's exactly what we're trying to prevent. So, putting another sentence in there saying the board can vote to have something else in executive session, just eliminate, just completely eats the rule.
Well, I'm not trying to say vote, right? I'm just trying to make sure that we have enough judgment to have a conversation in executive session, should we want to. That's all my point really is. It's not about voting in executive session or anything.
Beth, do you have an example? Give us an example of something that you would not want to, discuss publicly, and you want to discuss it only privately, the board.
It's not-
Give us an example.
It's not on.
It's not part of.
Jim's right. I mean, we went through this, I think, several times where we went back and we said, I thought about it, Shannon thought about it, Amanda thought about it. I mean, we all thought about certain issues, what were the issues that we thought needed to be kept private? And we tried to divide, and they basically do match up to what is in most state statutes. There are some other things that are unique to, for example, the KICA, like appeals and commercial assessments and stuff like that, or individual members, including committee and task force appointments. I mean, that's something that traditionally the board has done in private sessions. So that one we added in.
Rules and regulations, obviously.
Yeah. So, I mean, what we did, this one was one where we took a lot of time and we went back and forth. And if there's something that's missing, but I do think the community needs to know that this is, other than this, and as Jim is right, there's some flexibility here. I mean, one of the questions we got with the first one was, one of the comments was you could drive a truck through the first definition, which is legal advice. The problem is you can almost always drive a truck through the one with legal advice because you can always characterize if a lawyer's present that you're getting legal advice, even though it may not be.
All right, so I'm going to go back and see if I can come up with some examples.
Yeah.
And see how big or small that is and work through that myself and bring that back to your have issues. So
Hey, Brad, can I ask a question?
Yeah.
The goal today, I think you did a great job giving the background and the color around some of these. And it seems like we're already up to page 14. Is the purpose of this meeting sort of bring everyone up to speed with a lot of that background? And then we'll have a separate session where we really drill down on specific comments? Or do you want us to kind of go, point by point today?
This is it, Kevin, this is to do the drill down. If that's what this is, I mean, that's why we're having this meeting. If you have issues, raise the issue now.
I'll let you lead, but I would go all the way back to the first point that I sent you last night, Article 3, Section 2. It may be monotonous to go through my whole list and then Beth's whole list and then Lisa's list today. Maybe we can aggregate them at some point, but we kind of we're moving along. I think you did an excellent job of explaining the background and where we got to where we were, but I don't know that we were hitting every specific point on head that, to get through it. Like I could jump forward to, Article 5, Section 7 that we're in. There were 2 word changes that I suggested that I think would address some of Beth's concerns. Or maybe not, but do we want to hit those in particular along the way, or is this more of an overview meeting?
Well, I thought we were going to go through the high points that we saw in the document.
Right, and then you can add whatever you want.
to individual points that people.
Right, I mean, I think that, Kevin, we're trying to do it in sort of an organized fashion by topics, and I thought that was the easiest way to deal with it. If you have specific things, we'll circle back and we'll talk about them, but I'd like to get, we're moving along because I thought this would actually be an efficient way to deal with this. And I think it is a pretty efficient way to deal with it. You know, if you have specific comments, you're certainly welcome.
Yeah, I think the devil's in the detail on some of these. So whenever you think it's appropriate, maybe we circle back on some of those detailed questions.
Okay. Any more board comments? All right, community comments.
Maura McElvain, 146 Blue Heron Pond Road. The one thing in this particular issue that the board may or may not be aware of is this is a big community issue. And when I say that, some of the current board members don't have the benefit of the community reaction when the board was expanded. And it was done in an executive session, and then it was done in a retreat, which wasn't even a business meeting of the board. That's the overlay that you guys have to deal with. You have to deal with the cynicism in the community over what happens when you declare an executive session. And it's just the way the table's set for you. You weren't all involved in that situation. I understand that. But it's a real situation that this group is trying to protect the board against. Their job here is actually to make your jobs easier. And their wordsmithing has taken forever, but all they're trying to do is anticipate when you guys could get yourself into trouble with the community and the community sentiment could go against you. And they're trying to get you beyond the cynicism that this community still holds for this board.
And I think we've seen that recently. I mean, we saw this with the vote on the lawyer. I mean, that created, whether that, you know, whatever you want to make the argument about that, but the fact that it wasn't done in public was a big deal. And that's, we got to get away. The board needs to get away from that. The board needs to do its work in public, because right or wrong, whatever the board decisions are, people have a greater understanding and a greater appreciation. And they also understand that there may be legitimate reasons for both positions. But anyway, Carol.
Carol Medendorf, Parkside. Going along with that, as a community member, I like to hear the discussion both ways on an issue, so that if the vote doesn't go how I think it should, I want to hear the why part of it. And if it's done in private, I don't hear the why. So as a community member, I like to hear that discussion on issues.
But going back to the list we have here, we tried to identify things that we clearly understood needed to be private. And there are things that you have to do that have to be done in private, period. We know that. But we didn't want to leave it wide open that it could done. And I know it's being on a board and having been on boards before, you don't like to have it somewhat, excuse the expression, dictated to you what you can and can't do. But that's the only way to control it to a point where you don't have an open clause in there that would let anybody's opinion be done privately. So when coming up with examples, you know,
And to further that, going back to Brad's thing, once you're getting close to the line and there's doubt, go to the truly legal way to do it. If we're in doubt whether it should be in public or in private, it should be in public. If we get close to that line, unless it's one of these that has to be an executive.
Yeah, and I think what makes sense is to, take one more look and see if maybe something's missing. So I think we'll do that.
What do you think of that?
Dave, just to follow up on your point, I mean, obviously you have to do with Todd Bonet 3532 Shipwatch. Obviously, we have to do what's legal, but I think the other thing, and I don't think there's a way to write it, I think this is more of a philosophy, is that just because you can do something doesn't mean you should do it. And I think part of what we have to deal with is the appearance and, what we're trying to do with messaging and behavior. So, I agree with what you all are saying, but I think there needs to be in the decision process, some factoring in of appearance. And again, I go back to just because you can't do it. And again, you get all the legal advice you want. And it would be opposing the legal advice at many times, but just because you can't do it doesn't mean you necessarily should do it.
Totally agree on that.
And I think apropos to that, I think one of the things that hopefully helps the board is creating this procedure for announcing that you're going to have an executive session, which really doesn't happen now. So and reporting on what happened the way the town does. You don't use names. You don't, if you say we're meeting in the executive session, we discussed one of these items, we took no action, or we took an action. And I think just, bringing that additional level of reporting to the community that you had a session, that you took action or you didn't take action, and generally what that action was will help the community, have a better understanding of how and where you're making decisions.
A question on that, if that scenario happened and there was a 5-2 vote, whatever it was, would you want the names of the 5 and the names of the 2?
Yes, I think the directors want to, I think that the community wants to know how the board voted.
It could be general. For example, it was on an HR matter. 5 voted one way and 2 voted the other way. You don't have to describe.
Well, I think the language in here says including how each director voted.
Right, so you would have to name the names.
You wouldn't, for instance, say what employee, for instance.
Right.
It would just be, the action was taken, it was 4-3, 5-2, here's the 5, here's the 2, here's the 4, here's the 3, that's it.
I mean, that's going to take a little understanding and work to get to work through how you do that. But the idea is to give more transparency for the public, but also protecting the rights of the board and the rights of the individuals that may be involved in a particular executive session matter.
Any other?
Hey, Brad, I mean, for example, while we're on this section, we say, for example, immediately prior to any board meeting or following any board meeting, if we scratch the word immediately, can the board call an executive session if an issue comes up at any time, or can they only do it on the day of a board meeting?
They can do it any time.
That's something that's written right now.
That's how it's currently written.
Well, and one of the concerns that at least I personally had in this was that I knew sometimes that you all were going to have an executive session after the board meeting, but nobody else knew, and you all stayed around, the board meeting closed, and then you went into executive session with no announcement. It's just letting people know that you are having additional meetings.
Yeah, I don't think that's unreasonable at all.
I mean, you could do it, you would still have to announce it.
Right.
You're either announcing it at the meeting or you're announcing it by some.
But I do think the way it's currently written, you can't actually have an executive session that's not immediately following a meeting. You can't call an executive session.
Yeah. That was one of my comments, scratch that word immediately.
Yeah.
And then in the next paragraph, same example, directors may only consider and or vote. I would say scratch consider and or. I think trying to restrict a group from considering things is impractical, though I fully agree that you can restrict them from voting.
Right.
Well, and that's what the next section, section 8, actions by directors without a meeting. There's several different options for having different kinds of meetings in the bylaws now.
Yeah, I agree. I just would scratch. These are just a few of the details I had. Yeah, I would scratch the words consider and or.
So, I mean, I think you want them, the ability to have them consider it in an executive session. I mean, for example, if you're doing an HR matter, I think you don't want to have it considered in public.
Yeah, I think that's the part. I think you're reading it the opposite way, maybe, Kevin.
Yeah, I think you got to, I think that actually helps, not hurts.
Well, yeah, I mean, they may only vote on these matters, but we may consider anything, correct?
That's what this allows you to do. That's what it would allow the board to do, is to consider these items in an executive session.
All right, I was reading it the opposite, that we may only consider these matters, but we can talk about that after the meeting, but these are the types of things.
And we'll fix it. That's the intent.
All right. And this is where we're going to get into some of the stuff about the petition. So I wanted to go through that and why we did what we did. This is provide procedures allowed by covenants and bylaws.
I just this thing so I can look at some controls.
All right.
Kevin, can you still see the slides?
I cannot. I can only see the group.
You see the haystacks?
I can now.
We ready to go?
Yeah.
Okay. This was one where we had things that are spelled out that we could do, but we don't actually say how we do them. And this was, and this, as I said in the beginning, this is an area where it creates conflict. It just creates unnecessary conflict. I mean, we're dealing with sometimes situations where there's already conflict, and we don't need to throw an extra layer of conflict in it. So that what we're hoping to do is establish a procedure so that everybody understands what it is. It helps staff because they don't have to try to interpret something. They have a sort of a cookbook how they follow through. And they can either say it's met, not met, or whatever. There were no questions, but this is one of the ones that came up a lot. There were two questions particularly, was that there was a 5% threshold for members for a special meeting. That's actually in the statute. People said it was too low, but again, it's within the statute. As Jim said, there was no threshold really, which was a problem. I mean, you have to have some threshold so that you know what triggers a special meeting. So we put the statutory threshold in, which is what we're required to do. Questions came up
Could you
about.
go above that?
No.
No.
You can't.
The way but see, this part I don't understand.
Below, you can go below, but not, well,
Okay.
Right, because when you read it, first of all, if I'm reading the right section,
Which section are you in?
3331-702.
33, of the statute, okay.
Right, because that's what you're quoting, right? It's a statute,
Yes,
South Carolina statute.
yes.
Okay. So first it talks, number 2, it talks about the bylaws of a religious corporation. And then it goes into saying, if the holders of at least 5% of the voting power of the corporation sign, date, and deliver, blah, blah, blah. I think it's the words of at least.
Right.
Well, my first question is this tied to just religious corporations, the way they write
It's
it?
the opposite. They exclude religious corporations, if you read it, except for.
Okay, so it's excluding religious
Right.
corporations.
So we are a mutual
Right,
mutual benefit nonprofit.
right. So then it says at least 5%. So to me, the way I read it is that's the floor. And that you can go higher at least. And I do notice in the word, you use different words than this in the document itself.
Yeah. But I think when you say at least 5%, I think that does imply minimally, if 5% got together and signed a petition, that would be good. That would be okay.
The at least is not permission to, in our interpretation.
Go higher.
It's not permission to go higher.
No, it's a fundamental, there's a history to this that ties back to governance, to public governance regarding, rights of citizens, much like when I shouldn't say, much like when the petition was organized for the town regarding the annexation statute. And this has the same roots as that, where citizens, in our case, members would have the rights. So it's an extension of that. And that's a pretty typical percentage. I think the public one for the petition for the town was a similar number. So it's just a fundamental right that they maintain for these types of situations.
So 4% couldn't do it, 4.5 couldn't do it, 6 could, 12 could. Minimally, it has to be 5.
I think so. I think somebody made the calculation. That's roughly 270 developed lots, which I think is the correct.
It's 400 and some.
472.
472 votes.
Yeah. That's what I was trying to understand, the whole process, start to finish with, what I was actually trying to do is take the 2023 voting numbers, the record numbers, and walk them all the way through so I could just get a better feel for what are we talking about, the size of the population that would enable these compared to the size of how many people we actually have out there. I know it's small, but I mean, if you get all the way through, that's what I'm trying to do, and I
Trying to
probably got
contextualize it.
3/4.
To the extent it helps or not, the effort it takes to even get to that level is, having been through 2 of them, is extraordinary. And I don't think that you're going to find hope that, we certainly all hope that there aren't any decisions that would, going forward, that would create the need for something like this. But even getting that number just based on the fact that, first of all, we can't use the KICA communication channel. So you're dealing with trying to literally do it by hand and foot. And it's not an easy threshold to reach, even at 5%.
Okay, we've answered my question. Thank you.
All right, the next one, and this one did get a fair number of comments, was there was questions about the 5% threshold for KICA sending out a petition, which we said was the communication threshold. And I think just some background on this. When the court there is no, I don't believe I have authority either under your governing documents or under South Carolina law to require KICA to provide email lists. But he did ask counsel for KICA to say, how do you communicate with your members? And they said, generally by email. And he said, so then you got to figure out a way to communicate so that the members can communicate via email on these types of issues. And he actually said you need to do it by the annual meeting which was last year. We didn't meet that, but this, what we're trying to do here is we understood that KICA does not want to send out everybody's emails. So we tried to derive a process or to devise a process where KICA would send it out, assuming a certain threshold was met. And we kept it, we debated this a lot about what's the proper number, 5, 10, whatever. There is some logic to keep it to the same as the number in the, whatever is in the special meeting requirement, because if you make it too high, somebody can just call a special meeting and accomplish much of the same thing. So what we did is the process, and we can go to the next slide. The process that we set up is essentially
I think it's the third bullet, right?
there we go. So what we're trying to do is we're trying to address the court's concerns here. Plus, I think it was a reasonable request. It's that, when KICA communicates via email, it's unreasonable to require its members to not be able to communicate via email. So what we did do is we divide, if you meet this 5% threshold, essentially says, remember, a petition threshold to get a referendum is 25%. So if this is in order so that you can get a petition that has, see if you can get a petition that has 25% of the members signing it. So once you reach 5%, KICA has to send out the petition materials to all members so that they're aware of the petition and they can then decide whether they want to sign it or not sign it. One of the problems that came up, in the last, I think it's the only time we've had, so maybe not the last time, but the only time that we've had a petition, was you couldn't actually reach a lot of the members. They're not here. We don't know their, we could possibly get a mail address because that we could get. But you remember also you only have 30 days to do that. So the idea was that you would reach this threshold, go out to all the members, and then that triggers the 30 days. And that was a question we had for the lawyers is, can we do that so that that's the thing that triggers the 30 days? And so does that answer your question? I don't know.
Yeah, that part I understood, and I understood the logic behind it, and then trying to, I think, take the high road on the court action, which is kind of the way I interpret your earlier comments, and doing things what's like potentially or clearly legal. So you get around everything with the court, you follow what you prescribe as the law, and then we get the information out to the community so that they can actually see what the petition is.
All right, and as
I followed that, and I kind of think that's appropriate.
Is there anything with privacy laws? In other words, I just do not want my email.
we're not sending out your
They're
email.
not sending out emails. That's how they're going to
I
get.
mean, the list.
Let's see.
List.
KICA, that's why KICA sends it out. So so we're not having to deal with privacy issues. This was the way to try to avoid that issue. It's a little bit more cumbersome, but we thought, it's a reasonable way. I mean, we talked, Shannon, we all talked about this, how we could do this that made sense, and didn't impose significant burdens on anybody, hopefully, and got the result that we wanted, is that it gets distributed and people can make a choice. And I think that's, I think that's all the court was asking, is just so that people are aware of it.
I think, Brad, another comment is, I'm sorry, that I remember was asked to Shannon on several occasions, is administratively, can you comply with this? Administratively, can you comply with this? And obviously that was included in there to be sure that administratively they can comply with it, the amount of days, et cetera, to be able to comply on any of these things.
Right. There were a lot of things where we were asked, I mean, for example, there's things where it talks about, before it goes out, you have to, if there's, we change the language, it's not prohibited, it's not offensive language, it's now prohibited language. But that termination needs to be made. And also, once this comes back, there's an opportunity to check the names to make sure that the petition has the right number of names and signed by actual homeowners and things like that. And we talked to Shannon and said, what's a reasonable time for you? Understanding that we're trying to move this along too. So we have two competing goals. What's a reasonable time frame for you to do that work, with the understanding too that we don't want this to drag out. And that's why the time frames are what they are in the document.
Yeah, Tom Bonet, 3532 Shep Watch. So are you envisioning then that KICA would send out the petition and maintain the tabulation of the results? Or would this be, I file a petition, I've got some site that I'm going to use that tabulates the results, and I'm in control of it?
Yeah, you would do it. KICA would not do it. You would set up either, if you wanted to do it by hand, I wouldn't probably recommend it, but you would probably do it with the site, which is what happened with the town when the Reform It Now did. They did it with the site.
So, I don't know. If KICA sends it out, if we send it out, right, it goes out under our auspices, given the part of your preamble, Brad, about everything's at the direction of the board. I don't know how we rely on a third party to properly collect, tabulate, blah, blah.
I think, I don't think you're relying, KICA's not relying on anybody. All KICA's only responsibility is to circulate, is to communicate that a petition is ongoing. So it's the burden of collecting the signatures. We had pretty extensive conversations about this. The burden of collecting signatures is on the member.
But the member's also obligated, who's running the petition, to collect the names, the KIWA addresses, and the email addresses so that KICA can go back as part of their verification process. Like if I see Jim's signature, I know Jim, I know Jim's email, I know Jim's, mailing address. I'm like, yep, that's Jim, we're good. But that we can go back and test if there's things that if there's members we don't know.
I get that. I'm still not buying it though. I think that there's too much room for, trouble, bad stuff to happen. I think if a board sends the thing out, we ought to have ownership of making sure that we know what has actually come back. I mean, I hear your point. But if you, let's say somebody wants to do something bad. So they put the petition out, they're tabulating, and they come back with, a list of, here's the 16%, and maybe it wasn't 16%, maybe it was 4%, and somebody's padding the stats.
She has to then go and look at it.
But so then when you get that list, you're going to go to each one of those people individually and say, did you do this? No.
It'll be tested. We're going to go through each name and ensure that they're actually active owners.
Sure.
That they match our records.
Sure, but you're not going to verify whether or not they actually did.
Am I going to go to Maura and say,
Right.
Maura, did you sign it? I might if I had a doubt about it, but probably no.
But I see that as the basis for a controversy, right?
One of the things it was verifying signatures. I mean, you do have signatures on file.
I do not.
You do, you don't have anything else.
So Lisa, your concern is that that if I did a petition, I may sign Jim up and Lisa,
Yeah.
everybody else up. And when you didn't really do that.
Exactly. My concern is that as it's going out under the auspices of the board, to me, the board has responsibility for making sure that it's actually.
It's not going out.
That's a disconnect. Yeah, it's not going out under the auspices of the board.
The board is not endorsing this. The board is taking absolutely no position. In fact, it will probably have a legend that says, this is not the position of, KICA.
Okay.
The board is sending this out just for informational purposes only.
And with all the great lawyers, I'm not trying to be a pain in the neck. With all the great lawyers out here, somebody's not going to come back and say, this came out from KICA, which runs under the board. The board didn't do its due diligence, therefore this.
But understand, all this does is that once you get to the 25%, then you have a referendum.
Yeah, totally get it.
Then the referendum is run by KICA.
Totally get it.
And remember, this is only in association with board decisions. So the board is clearly, if there's a petition against a board decision, I think you know what the board's position is going to be. We need a board decision. And
That's
all
what I
we're
was going to
talking
say.
about. We're not talking, special meetings is a different instance, but for this referendum, it's only related to board decisions.
But Lisa brings up a good point. We didn't get into the detailed process, but someone should go with Shannon on the audit committee or to like go through the process like you do as an auditor. You check the books, you don't check 100%, but you're going to do a sample and.
And I don't know who was at the council meeting the other day with with when Isaac spoke. And the county has a very a process that we learned about when we did Reform It Now. And it's a very similar process where they spot check. So you can actually contact the county if you want, just see what process they
When
undertake.
we get into the procedure manual, we probably ought to poke this pretty hard and make sure.
I think it'd be I think I would leave it up to staff because the staff
That's what
has.
happens at the county. Staff basically does some verification.
Right.
And yeah, Brad, if I could add, the thing I like about this approach is that if all KICA is doing is disseminating it, sending it out to site, and I, as the individual behind the petition, have created the structure of the petition, now I have had people's email information. So now I'm in a position that I can communicate directly. No, if they went to the petition and filled out the information I requested, I'm now.
Carol gave it to me, so
Right.
Carol.
Yeah, we're not trying to privacy standards, but I'm now in a position that I can communicate directly with the people who seem to be interested in what I'm trying to take care of.
So I think that's another good point then with respect to the codification of this, then on the communication that goes out from KICA, we ought to have a bit that says, oh, by the way, make sure you understand that if you reply to this, a third party other than KICA now has your, email address.
Yeah, you should be unmuted.
Now can you hear me?
Yes, ma'am.
I just have a question about this 5% threshold. It was my understanding, right or wrong, that if our bylaws do not contain a percentage threshold, say 5% or 25%, and then our covenants do not contain a threshold 5 or 20 or 25%, then we go to the South Carolina statute that would dictate. So it's a 3-step process that we default to. Is that right?
It depends on how it's written. There are specific provisions in the Not-for-Profit Act that say, to the extent not otherwise stated or provided in your bylaws.
Exactly. So it's not a mandate or a dictate from South Carolina.
It's not one of them, Jay. That's the problem. There are specific ones where it says you can have something else in your bylaws or covenants. And if you don't, this is the default. This one is one where this is what you have to have.
It says in South Carolina statutes that no matter what any homeowners association wants to do in South Carolina, 5% is the absolute, and you cannot deviate from that. Is that what you're saying?
That's the way we read it.
For special meetings, yes. Dave, you understand?
No, no, I'm not talking about special meetings. I'm talking about the dissemination of a petition.
Well, that one we decided, and we thought it was a reasonable number because we thought it made sense to match the number for a special meeting. Otherwise, you're just going to have more special meetings.
Yeah, the 25% is in the covenants. So we couldn't change that number.
For the referendum.
For the referendum, right, the 25%. The communication threshold is a number, yes, that we had to arrive at after discussion. And again, the purpose of that was to avoid having to give out the email addresses to the community. That's why we created a process to shield email addresses from the community, but still allow in that type of situation for the community members to be able to communicate. But it doesn't result in any action. That 5% is simply for communication. It doesn't cause a referendum, doesn't cause anything. But yes, that the 25% is in the covenants. So that's what.
Okay, so I sent my comments back, one of which was, I think 5% is too low. It's a small number compared to the number of people that live on this island now that we've got so many new residents and stuff. I just think it's the tail wagging the dog.
It's 5% just to communicate. It doesn't result in any action.
Right.
But your 5% to communicate creates a lot of work for staff.
But then they'll call a special meeting.
The alternative, if you change it to 10%, they're just going to ignore that and call a special meeting at
Yeah, so
5%.
could you explain when you say call a special meeting, what are we talking about there in terms of you call a special meeting, everybody comes into their meeting and then you get a
You have
signature?
to give a notice, you have to give 30 days notice, everybody has to come in. I mean, you want to talk about something that's complicated and has a lot of steps. That's a real problem. All we're talking about here is the KICA will send out an email. That's it. They'll
I
send
get
out.
that, I get that. Why would, so if you're gonna do a petition more, why would you want to go the special meeting route? That's what I'm trying to understand.
If I only need 5% to get people in the room,
And you get them in the room to do a vote or
Right.
sign a petition?
Which is easier.
So then what you're really saying is you need to keep these two things in tandem.
That's
to
right.
be in tandem.
That's why we chose one of the reasons we chose 5%. Plus, Jim's point is, if you actually go and try to get 5%, it sounds easy, but it's not that easy. You know, it's not like somebody's going to be you're going to have to get a significant number of people energized about whatever issue you're dealing with to get 5% to sign up.
See, I
But
think,
then why did you choose 5%? Is a random number?
no, it's, what they're saying is the South Carolina law requires that for a special meeting. That's the amount you have to use. It has to be at least
Okay.
that much higher. And then they're trying to match that to the communication threshold so that people have the choice of either going out, using the emails to get the signatures or calling in for a special meeting. I think that's
So if you had both of them at 25%, so you have 25% as it exists in the covenants, and you made this petition number, for lack of a better description, 20, and kept it at 25%, that's a problem? And if it is, why?
25% is to get a referendum. It makes no sense. We haven't complied with what the court wanted. If we say, in order to get a referendum, you have to get 25% for the communication threshold. We haven't satisfied with the court. And, you know.
I didn't see anything that the court said that 25% was the magic number. I think they said that it needs to be discussed and addressed.
Right, and that's what we're trying to do. And we can't do it. The 25% is the threshold for a referendum. This is just publicizing it. That's all it is. It's sending out an email. If we're talking about which is more cumbersome for staff, having a special meeting is more cumbersome for staff and takes more time and is more complicated. This is a much simpler process. And, you know, we've only had one, as far as I know, one petition, maybe two, maybe there was one. So we're hopefully not talking about an everyday occurrence. We thought this was a reasonable one.
If you have a special meeting, does KICA then have to advertise the special meeting?
Yes.
So isn't it the same thing?
Right.
Except sometimes you don't have the emails to do it in a special meeting, or,
But KICA's doing nothing different than.
yeah,
advertising
but you're right,
special
they
meetings.
have to advertise it, so they're gonna use their
Right,
emails.
it's the same thing.
Yeah,
Kika only has the emails, just let's clarify.
right, no, but to advertise it,
We don't.
put it out their media.
Yeah, through Kika, we can't ask Kika for the emails.
The only way people get emails is if they voluntarily decide they want to give the emails. And then that's their choice.
Right, and we just, and my point earlier is we just need to remind people, because sometimes they forget and then they complain, although we clearly witnessed that a lot of people don't read stuff, so that's a different matter, but.
One of the things, if you were in court and listening to the judge, the term address came up. And that's when he asked, how do you communicate with the community? Via email. The question is, when the statute talks about you have to give the address. And I think that because that statute was long before the internet, the address is their mailing address, which by statute we can get. But I mean, what are you gonna do with 5,000 mailing addresses? I mean, so that's crazy. Theoretically, we could change our covenants or change it somewhere that define address to include physical mailing address or email address. We don't want to do that because it's so much easier just to give staff, send this up. So we don't get the emails, so we can't use them for other purposes. So.
Right. I mean, this is all driven by the fact that the board did not want to give out emails, and we got that. So.
Protection of the members.
I don't know. I still think 5% is too low a number. I don't know what the magic number is, but that is too easily accomplished by small groups of people. And I don't think it benefits the community as a whole. And I don't think we are ordered by any law that it has to be 5%.
But Gay, if it's 10% and people want to get something done, they'll just call a special meeting. They'll go, that's 5%. So, I mean, you could put this communication threshold at 50%. Nobody's ever going to use it. They're just going to call a special meeting because they only need 5%. So
Maybe that needs to be changed.
you can't, it's by statute.
That's the law.
So it's, I mean, I understand what she's saying in terms of the percent seems low for a community our size. And you've got a small group of people that then can drive the whole thing. I mean, I have that concern too. And then you get to a point where you do more and more of these because it's easier to do. I don't like that either, but I don't think there's any way around it.
Well, I guess there's one thing. I mean, this is more democratic to do it this way. And I hope that we all agree that doing something that's having our members being able to have input is a worthwhile goal. So I'm a little concerned when we say that, you know, well, members could actually vote on something. I don't think that's a good message for the
I
board.
don't think I said that.
The other thing I would say is, having been involved in the last two petitions that were initiated on this island, one for the town for Reform It Now, and one with respect to the expansion of the board, it was not easy. One succeeded and one did not succeed. But it was not easy. And so the idea that you are lowering a limit and you're suddenly going to get this onslaught of petitions or referendum, I don't think you should be that frightened of that possibility. That's all.
I think in the system of checks and balances, with the option of having a special meeting, I think the message that goes out to our community is that we are trying to be more democratic, as you say. And I think to Maura's earlier point, that anything we can do long-term to diffuse the distrust and the animosity that people sense as part of the board fabric will be a positive for us.
Right on. Any other comments on this? So we'll move on. All right, the next one was trying to address issues which have arisen over the past and reduce conflict. And the primary way we did this was we were concerned about the number, and by and large, on most of the issues that the board addresses, were unanimous. I mean, the votes, it's a minority of votes where there is difference, but they are oftentimes where there's a split. But when there is a split, it's generally over something that people feel very strongly about. And what we tried to do is say, okay, can we do something to kind of push the board to reach more of a consensus, not complete consensus, but more of a consensus? Can we do things that, and what we decided to do is on certain issues that we thought could be contentious, make it a supermajority. Originally, we put in a provision that some of them were unanimous. We got comments about that they didn't think that was appropriate. Particularly, one of the concerns was that one of the board members is not an elected member, and that may create a veto, the ability to veto. So what we walked it back to a supermajority. We put in 3/4 right now, we got no objections to the supermajority concept. The only objection we got was the issue about unanimity, which we have addressed in this. And one question was, where are actual supermajorities required? And you see them listed there. It's changing the name of directors, removal of elected directors. Now, this one did have, one of the things, let me explain why we decided to do removal of elected directors, because as a supermajority. These draft bylaws have every officer on a 1-year term. So they're reelected annually, assuming they're still on the board. The thought was, if you're going to remove a director with a 1-year term, it's a pretty serious matter. It also.
Hang on. I think you mean officers, not directors.
Removing an officer, it's a pretty big deal. So if you have an officer in a 1-year term, plus it has negative connotations in the community. And the thought is that if we're going to do this, it should be more than just a majority. It's a serious thing. It should be done. Now, it can be done for any reason, but it should be done. There should be more than just a bare majority to remove an officer. Because board members cannot be removed except by members. We have added one provision where board members can be removed for example, like failure to show up at meetings and failure to pay their assessments, which seems, and it's not mandatory. The board can do it if it wants to. And that's one that also requires a supermajority. But the idea here was, because we are a community association, and we're dealing with our community members, that removal of an officer is something that shouldn't be something that just can be done. That it should require a supermajority. So that's the one why we did that. Holding special elections to fill a vacancy. Again, we've defaulted, the appointments, because that's the way we view that holding elections is clearly legal. Whether you can appoint, somebody can make an argument that maybe the court decision didn't address that issue, or it's not that far, didn't go that far, but there is a serious question about it. And again, if we had a choice where holding elections is clearly legal. Be something that we don't want changed without some sort of more global agreement. So
I'm not aligned. I mean, can all talk about the last year, the last 2 months or whatever. I do think your point about the fact that the directors are elected by the community to represent the membership is a key point. And there are differing points of view. And I think a majority is the way to go. I think that's just, to me, that's a sort of a standard operating procedure. It is what I expect in most cases, is a majority.
And each one of these, or?
No, probably not at each one.
Yeah, I think you gotta go one by one, and maybe can we do that, Fred?
Yeah.
Sure, yeah, I think that's what.
Each one's gonna have.
Yes.
I have some different questions of understanding on a couple of them. too.
Yeah.
So Brad, before we go through them one by one, there are 4 of them that I just want to note as currently drafted are not consistent with your point number 3, bullet point number 3, where it says super majorities of vote of 3/4 of total board members. They actually say elected directors as opposed
Right,
to.
that's some of the confusion I have on a couple.
Right, so there's 4. There's Article 4, Section 6 and Section 9, and then Article 7, Section 4, and Article 8, Section 2. So as we go through each of these, I would like to have a discussion about whether excluding the appointed director is appropriate or not.
So let's just start, if it's okay, that we go through one by one.
I think that would be
I
great.
just, if you have the document in front of you there, I know I missed one, I can't remember which one it is, but they're marked in yellow, so just a little bit easier to pick them up where we talked about any decision that wasn't required, something different than a majority.
There was something out there. Did we ask the lawyers whether we can exclude the unelected director in the vote? Okay. I know we've included sometimes here where Amanda can't vote, right?
Right.
Did we specifically ask the lawyer?
Well, it's not that you can't vote. You can vote.
It's just the vote doesn't count,
Right.
the way it is drafted. Well, we can just hit each of them as we go through. I think that would be best.
All right.
67% rather than going to a 75%. I just thought that was any kind of documents not that I'm the expert in documents like you, but any of them that I have been involved in and worked with where we identified a supermajority, it was always 2/3, 67%. It was never like 6 out of 7. It was always 5 out of 7 or something like that. So I'm more comfortable with 2/3. That might not be a good enough explanation for all of you, but
2/3 would be 5. 2/3 would be 5, and 3/4 would be 6.
And just.
Yeah, this
for
is
the-
Kevin. I agree with that. I think it should never be more than 5 out of 7. And in some cases, I'm sort of leaning where Lisa is that it should be 4 out of 7. But I don't think in any case we should be going to 6 out of 7.
Yeah.
And just for the audience, the section that the boarding task force are debating right now is about changing the number of directors.
Yeah, I'm sorry.
So I'll try to keep you with where they are.
Well, I mean, just to play devil's advocate on this one, I mean, this is a pretty significant move. I mean, again, part of the goal is to actually force the board to talk to each other. Because one of the problems that we've had, and it is a significant problem, is when somebody gets 4 votes, a lot of times discussion ends. And part of this is to force actually discussion, and the idea that if you get discussion, you hopefully get a better answer. I've always been of the mind that you get the best results when you understand, because that's how you resolve cases. I litigated cases, but actually trying cases is a small minority of what you do. You resolve cases, and you resolve cases by understanding the other person's opinion, what matters to the other person, and try to reach some sort of consensus. So I think what we're trying to do here is we're trying to force the board to talk.
I think that's a pretty reasonable goal. I'm not sure I'd achieve that goal by saying a supermajority is the way to achieve it, because I'm not sure you change anybody's point of view. I think if what you're trying to do is encourage more conversation, and perhaps in the procedure manual, you talk about, everybody on the board has to put an opinion forward before the vote is taken. I mean, if what you're saying is some people won't talk or some people won't speak up, I get that.
But
So
it's-
maybe it's
But
procedurally.
as a practical matter, Lisa, what happens is there's a calling around, you get 4 votes, and then that's it.
Or gridlock. Or gridlock. The fear is that you tie the board's hands and you have something important to deal with, and you literally get to we've got 5 out of 7, we can't get to 6 out of 7, and we literally can't move forward, and now we have a real problem.
Yeah.
Well, in this case, Kevin, no, you're just talking about expanding the board. It's not that the board can't function. Let's focus on this particular issue. This will not undermine the ability of the board to operate on this particular issue. Look, just a couple comments on this. One is that most HOAs that I looked at, the board has no right to change the number. It's the members that have the right to change the number. So it's unusual and it's not exclusive to KICA. Others do have that right, but many others have it where only the members can change the number on the board. The second thing I want to point out is that one of the things that we tried to do was to identify where politics would interfere with structure. This is clearly one of those cases because as we saw 2 years ago, it was for political purposes that the board was expanded. That was the purpose of that expansion. It wasn't functional. It wasn't that anybody sat down and determined 7 people is enough. We need 9 to do the work we need to do. It was done for political reasons. We tried to go through here and say, we want to divorce as much as possible the politics from the operation and structure of the board. And this is one of those instances where you don't want this decision to be made because you don't like it. You see an election where it might not go in your direction, so let's expand it, which was what happened, frankly, the last time, and why the board was expanded to try to avoid a change in the majority in whatever the majority means in the case of you guys. So that's why we chose that number, and that'll come through in other instances where we're trying to divorce the politics from the structure of the board, trying to save you guys the angst and controversy of that.
So why didn't you go for member vote then, if that's how you kind of felt? What was the discussion on that?
We didn't feel that would be tenable to you guys. I mean, there's a line, you can only go so
I think
far.
of all the places where we're voting on different things,
Right.
this is probably the most important.
So I think the suggestion is, because I'm not sure I'm dramatically opposed to what you're saying, Jim. I'm not sure I agree with all the background prior, but I'm actually a big proponent of the board being 9. When I look at, how much time and effort we spend, which we all signed up to do, but I'm not sure we all signed up to do this much. And given all the work that's coming up, I actually am a proponent of the board being 9. Maybe we make the board 9, choose to make the board 9 now, and then, maybe you can live with supermajority or 2/3. I don't know.
Well, the 9 is, that's another topic. We should stay.
Yeah, but that's what I'm
here
suggesting.
on what we're talking about. But
And Kevin, I think you feel similar to that.
I would agree.
similar to which part?
To what Lisa's saying. I just wanted to get it out because I know how.
I recall
9?
when we were expanded we were expanded properly, but the appointment didn't work.
Right.
One of the members of the community did some research and there was a study done by Mitt Romney's company, Bain Capital, and they said for nonprofits of our size, the ideal number is 7. You go over 7, it becomes 2/3. If you go under that, you can't get enough people in a meeting. So that was research done by them. One of the things that came up at the time that the board members have too much to do. We need board members to do stuff, etc. When you run for the board, you gotta be committed to it. Okay. We need board members because we have too much to do as bulk. Okay?
Yeah,
We don't have that much to
There's a
do.
lot of, I don't think it's bunk. I think there's a lot of scope here. I think there's a lot of issues. We've got the ARB, we've got, there's all kinds of things. You know how much time you're spending on, the sandcastle we're gonna need to think about.
But this is why we went to
Yeah, I
task
think-
force.
I think we're off topic.
Yeah, I think we're on
Whether
topic.
we're 7 or 9, the only conversation.
The only reason I brought it up was because I think if there are 9 on the board, you might more easily wrap your head around a 2/3. That was the only reason I brought it up.
I think the debate here is really going to be, or should be, is it 2/3 or is it 3/4?
Is there anybody that,
We have to just think about that.
does anybody go beyond either 2/3 or 3/4, so that we know sort of the parameters
What do
of
you mean
where?
go beyond?
Anyone feel it should be unanimous
Unanimous?
or,
No.
Or majority plus one.
Look at the math, it's not a huge difference between 0.67 and 0.75. Okay, not every time, it depends on how many people are voting. If you're looking at 7, there's a difference. If you're looking at 5, there's not a huge difference. If you're looking at 4, I mean, if only 4 people are voting, it's gonna have to be unanimous. If you go to 1 over simple majority, which is one way to look at it, okay? If you got 7, you gotta have 5. If you got 6, you gotta have 4 as a simple majority, so you gotta have 5, okay? If you got 5, a simple majority is 3, you're gonna have 4. Okay, if you got, and 3 isn't enough anyway, so 4 over a simple majority, you gotta get all 4. If there's only 4 people voting, simple majority is 3. If it's 1 more than that, it's gonna be unanimous.
Why would
If
there
you-
only be 4 people voting?
If people are out of the country and they don't vote, I mean,
But it's the 3/4 of all the directors. It's
Yeah.
not a who's attending.
All the directors.
okay, so if that's it, so if it's, then what's 1 more than a simple majority?
That would be the 2/3 in that case. That
It's
would be
fine.
5 out of 7.
It's 5.
Yeah, it'd be 66.
It's 3/4 and 6. So that's the question.
All I'm trying to figure out is the parameters of where we are. So
2/3, 3/4, or expressing it the way somebody else is expressing.
Yeah, majority plus one.
Or just majority.
So,
Plus 1.
okay, I got,
I'm not a majority.
yeah, we got that. So that's when, that's helpful, because that, now we know what the parameters.
I'm good.
You're good?
Well, what were you gonna say, Todd?
Again, Todd from Day 35 ship I think, but I kind of agree with you that let the members decide because they're the ones voting for the directors. So they're involved in the process. I mean, at least I agree with you. I think you all have a lot of work coming up here over the next 2 to 3. I appreciate everything you're putting into it, but yeah, I think there is some symmetry to having the members to decide. And quite frankly, I don't think no one's going to decline to, approve an expansion of the board. Especially if it's occurring as part of the election process. The other thing, just something is that the language says that the expansion will be done at a special meeting. I think it needs to say a special meeting or an annual meeting.
Would that include something of a personal nature that you'd have to put that out there for the entire community and therefore you'd violate, somebody's confidence and privacy? If there were an issue that, in other words, you want to remove an officer, a director.
Oh, I'm not talking about removal.
they're only on the
We're
number.
only on
Expansion of the board.
the number of directors.
The number.
So are you saying that you put, I mean, that's an interesting question. Would you put that as an election issue? So in addition to,
The board is recommending, again, you have a majority. The board is recommending that we expand the board and here's a slate of candidates. And it's part of the same vote in a sense.
It would be 2 votes, wouldn't it?
Yeah, it's 2 votes, but
I'm not the lawyer.
So we have 2 issues. One, that we're talking about the number, but Beth brought up a good, why don't the members do it versus the board? So we just went into the covenants. And if I'm reading this right, where is it?
Right here.
Okay, the association shall be governed by a board of directors consisting of 3, 5, 7, 9, or 11. Initially, the board shall consist of 3 members, with the number in subsequent years to be determined by the members of the board of directors, as provided for in the bylaws of the association. So unless we change the covenants to have the members do it.
Well, I think the state statute, I'd have to go back and look at the state just to make sure.
I mean, I would love that. I think the members should do it, but we're.
I mean, the state statute may give the members the right.
The board,
I'm not sure. But
that's the power, but the board could also defer it to the members.
I guess.
Yeah, but I think that this should not be and I assume it won't be, this should be a studied decision by the board. There should be a rationale provided to the membership if you want to expand why you're doing it.
Yeah.
Unlike what happened, I think that's what created the contract. There was no.
Right.
Okay.
I'm on.
So we're agreeing on 5 related here.
we're down to 6 people. That would, so that comes into it.
All right, so the next one. Article 4, Section 5.
So what do we agree with? I mean, do we agree?
I think it's either 2/3 or 3/4.
Oh, we haven't made a decision.
No,
Does anybody have any strong feelings either way other than?
Yes. Yeah, I would be not happy at 75. I think 66 is the right number.
I think the concept of filibuster, you know, when you get back to the politics, the reason filibuster is still alive today is exactly because of that. So politics doesn't get involved in serious important decisions. That's really what.
so this one we haven't decided, so just, we're gonna leave it open.
So that's the motion. It's majority plus 1, 2/3, or 3/4.
Yeah. I'm okay with whatever we agree to, but above unanimous. Simple majority, I'm sorry.
Majority.
This one, Amanda votes.
Right, that was my.
I would argue for 66.
So. It's actually section 6 because it got changed. It was originally section 5, but then it's section 6. Elected directors by the board. This is something that we added that says that if you can, it's a permissive that if somebody has 3 consecutive absences, and the reason it's permissive is, for example, if somebody gets sick or something like that, you know, then they're absent. We assume the board wouldn't kick them off because they're sick or whatever. But if they're just not showing up because they're just not showing up, that's a different situation. So that's why I made it permissive.
I think this is the exact opposite of the ruling with respect to appointment. So when the judge said the members elect, I think only the members can unelect.
He's talking about election of board members, not election of officers.
No, he's talking about the removal of an
Removal of
elected
the
director,
director.
not an officer. An elected director.
And there's specific, if you look at it, there's like specific reasons why you would be removing.
I think this ends up on the cutting room floor, truthfully, because I think if only the members can elect, only the members can unelect.
Well, this is, you know, I don't disagree with that, but what I think what you're trying to get at here is a situation where you put somebody on the board and they're not doing what they're supposed to be doing. They're absent because of certain reasons.
Put anybody in the
Here.
elected.
They're not paying assessments. There's just something really delinquent with the person needing to take action because think about it. Let's say we're still at 7 people and then we've got one and we got a lot of work and we got one person who's unable to show up for whatever reason. We need to do something or we're just crippling ourselves.
I don't disagree. And I think that if only the members can elect, then only the members can unelect.
We wouldn't know the reason though. We might not
You
know.
know, I agree that you wouldn't necessarily make it public, but I do think, I thought the judge's ruling on that part was pretty clear and that only the members can elect. And I think and only the members can unelect.
What do the covenants say?
The covenants referred to something?
No, this came from, this was a provision in the Hilton Head bylaws. And we put it, when redrafting, this was put in and we discussed it as a committee. And I don't think anybody had strong feelings one way or the other on this particular provision, other than there should be, if there's really a derelict board member, that there should be a provision. But I don't think, I'll speak for myself, I didn't have.
My recollection of the covenants is there is a provision by which the members can vote to remove a board member.
And it's actually a
Statutory.
Statutory. It's one of the-
Exactly.
We wouldn't know if necessarily if a board member is abdicating or in arrears in assessments or otherwise
Right.
not contributing. So then the question is, how do you inform the members so the members can then initiate under the covenants what they need to initiate?
Yeah, you probably don't. And I just think that if you think about it from the perspective of only the members can elect, I think only the members can unelect. I get that leaves, potentially yucky behavior unexposed.
You can also have a situation where there's like a director is having a serious family issue.
You would
And-
assume they would resign.
And I mean, well,
Well, and it says May.
And that's,
It says May.
May. Yeah, we specifically, that's why.
Yes, it's May.
That just in case there's like.
It was to cover that. So for instance.
It's not only May, all the rest of you have to, all the rest of you elected directors.
We have to agree.
and I did, and that was one of the questions, why am I excluded or the role?
So this, you can't be removed. And I think for you to participate in the removal of an elected director is something that doesn't make any sense. I think the elected director should decide, why should you have a say, I guess, in whether an elected director is removed? You weren't involved in their election. It's a separate appointment. And I mean, this is a narrow case. It's not really that significant one way or the other, quite honestly. Yeah, I think as a philosophy, the philosophy was if there are decisions that involve that are based on the subset of elected directors, that the elected director should have the right to make the decisions about that. If it has to do with the structure of the overall organization, then absolutely, the partner should have their say in that. But if it only affects elected directors, why it should be the elected directors that make the decision about other elected directors, not the developer director, not the appointed director.
Well,
It's not involved in their election.
I hear you, and I think we'll have to debate it as a.
It's an interesting, and I will admit, it's an interesting topic.
The advantage to defining.
Board, remove the partners.
Never. Yeah.
So if we can't remove you, you can't remove us.
It's simple.
Yeah.
I think they were trying to give to the board of directors a way to handle something that's completely delinquent without having to go to the cost and time to put out a vote to the membership, right? So they were saying, okay, in these two narrow cases, the board who knows all the facts may choose to do this.
And the two narrow cases are not participating.
Not participating for 3 consecutive meetings, or you have had a lien filed on your property for failure to pay assessments.
If I was out of the country and missed it by a month.
We don't file liens for 20 days.
Get to the lean point.
You should really pay your assessments.
I think those two very limited, where it says may, is appropriate, because if it gets to that point, somebody's not showing up. If we can't convince them to resign, we got to get rid of them.
I think, because, I think the assumption is before anything would happen, there'd be a discussion with the person and say, we'd like not to, but it gives you a hammer to actually insist that people do their job. And I don't think that's a bad thing.
And it is unanimous.
Right. It is unanimous.
And if it's
It's a very serious matter, unanimous.
if it's because of a lien, I don't know if you're able to disclose that information. Be careful of legality of taking it out to.
First of all, wait a minute, a lien is a matter of public record.
Okay, you're right.
So, those are.
I'm not with unanimous.
Yeah, I was gonna.
For, 2/3 or 1/over majority, however is the best way to express it.
Oh, sorry, I cut out there, but I agree with Beth. I think it's 2/3 or some type of majority. I think you could say that they don't participate in meetings over the course of like a month or 60 days. So nothing happens if someone's out of the town for a week or two while there are special meetings. And I do think it's so tightly constrained that it's not a risk. And as Shannon said, going out to the world to take an election for something like this, when it's obvious, the board should be able to settle it.
Yeah, but it's regularly scheduled. It's not specially scheduled meetings. So it's regularly scheduled meetings.
Right, so it's your calendar.
Okay, good.
Here's the problem. Let me tell you what the problem with unanimous is here. You're only going to have 5 people voting on this because the person that you vote getting out is not going to be able to vote. If the member is not voting, you got 5 people, which effectively means that a simple majority of the entire board can remove somebody. So make it unanimous.
I didn't think of it that way.
I don't agree with the point that the person in question can't vote.
Well,
Of course they can't vote.
Sure, they can vote.
The vote won't count.
Why won't their vote count?
It's a direct conflict.
So we'll get into that later, but I think that as background doesn't fly. And the reason I raise this is not because I'm opposed to it, but I do think it's an interesting point to consider that if only the members can elect, only the members can unelect. Maybe I'm way off base.
That's fine, but if you're voting somebody off, first of all, if we're voting him off because he hasn't shown up, he's probably not there anyway. All right, if he's there to vote, we probably don't have the problem. And if he's got a lien and he doesn't get rid of his lien,
I'm not saying, again, I'm not saying I am opposed to this. I am saying that if only the members can elect, then only the members can unelect. And
I
think it's
agree with
important.
that, but that means you only got 5 people left.
And I'm talking members, the membership, right? If
So
only
if
the
you go
members.
with that, if you go with the
I
members.
agree with you on that one. I'm talking about that if you have the vote, and if the E-member can't vote, and if the person that we're trying to vote off, the board trying to vote off,
Yep.
can't vote,
Don't agree,
there's
but
only
yes.
5 people left.
Right,
4 people, if it's 75 or 67%, 4 people.
right.
That is, the 4 people, unfortunately, depending on how it comes up, is a simple majority of the 7-member board.
Yeah.
So it should be unanimous of all 5 that are left.
And that's why you're going for unanimous.
Unanimous vote of the other.
To
elected
avoid-
officers.
Because theoretically, you could have 4 members of the board of 7 saying, we want this guy off. And if you do it at 75% and he can't vote, and I can't imagine
I can do that.
somebody in that situation is going to be voting, whether should be or shouldn't be.
You're with the
It's a very
philosophical.
small, it's a very small window to remove a board member. I think there's a very small window. This is not a very broad type of.
Again, so I'm clear, I am not opposed to what's written there. We'll haggle over what the number is. I just wonder aloud, if only the membership can elect, then perhaps only the membership can unelect.
We've heard that, yes. We're saying this is a very small window for us to, not comply with that. This is a very small window. That's all we're saying.
Isn't it true that if you have a lien against your property by KICA and you haven't paid, you're not even eligible to be a board member?
We're not a member in good standing at
You're
that.
not considered a member in good standing.
Right. So, I mean, it's an automatic trigger. It's not something that's subject to vote. Now, I suppose if you make stuff up on your resume or something, but.
As a community member, Carol Medendorf Parkside, I don't want to pay 20,000 for an election to remove somebody. That's not a good use of my money.
That you think is obvious.
That I think is obvious. Well, I might not even know. I have to vote somebody out and I don't even know if it's a lien.
All right, well, that's a good point too.
The other thing is, if you're going to have an election like that, while you're going through the process of an election, the person comes back in compliance.
What do you do with
Then what do you do? You blow 20 grand for an election and he pays his.
Well, and I think,
And I think the decision kind of goes to, if we want to stay with the members elect and only members can unelect, we just scrap this all together and don't have any option for the board when the situation comes up. I think it's, do we want to have this kind of an option for a situation that's probably unusual, but could come up?
that's what we decided. It was unusual, but it was serious enough that we thought it should be.
Gives the board an option.
And we put
Do you have
May
any
in
right-
there.
do you have any right statute under the statute to remove a bad actor? Because you can't remove a bad actor, is the way I'm reading this.
Under the statute?
Yeah,
No, you can.
you can. So we don't need to state it here because you can remove a bad actor.
Yeah.
Okay, thanks.
I would respectfully disagree though, Jim, about whether or not the appointed director should vote in matters like this. So just noting.
And I guess my view on that, Amanda, is she's sitting here experiencing the whole thing too.
I mean, it's something for you to decide.
Right, she's experiencing the whole thing. She's part of the board. She's dealing with this right along where we are in this very limited fashion. So I don't really have a problem if she votes in this specific case,
Because it's unanimous.
especially if it's going to be
I
unanimous.
have no problem, either, but unless it's not a majority, it's got to be a little bit more than a majority. It's got to be more than a majority.
It's just part of the unanimous vote.
Right,
Right.
but maybe it isn't, but back to the effective veto concern, maybe it is a supermajority whenever I'm voting, right? Because that is a concern also, right?
So if we just said the other directors, super majority, and it would be, I assume it's either the 2/3 or 3/4 down to that.
Well, assuming the person we're removing can't vote.
Correct.
A supermajority
And
of
that's the way-
67 would be 4 and
We'll
have to come
75
back
would
to
be.
that.
That's the conflict, that's the it gets, we're in the
Right.
conflict.
Yep.
So so if the member who's getting ousted can't vote, 67% is 4, 75% is 5. So that's where we got to get to that 75-67 threshold.
So if there's 7 of us, the simple majority is still 4, but only 6 would be able to vote, so the simple majority is still 4. So I'm starting to come around to the simple majority plus kind of concept.
Yeah, because in that case, the simple majority,
That's still going to be the 5 out of,
if it's 67%, that's why I lean towards the 70. If it's 67%, 6 people are voting, it's a simple majority.
So you're leaning towards instead of simple majority plus 1.
On that one, it would have to be simple majority plus 1 or 75%.
I think we need to look at this holistically too. We hate to,
The math plays differently depending on.
once we go through all these.
To run the numbers.
I think that's an interesting, different way of looking at it. It could solve some of these issues.
we're not wedded on it being the same in every case, right?
So we're going through one by one. So. Section 4.8, which probably moves to 9.
I split. His comment. Split up.
Yeah, I get it off the old.
Split up section 3 into section 3. Section 3. Thank you.
Section 9.
Section 9, this is vacancies.
Right.
Just because this did have some questions about, for example, why it was that it was six months. And what we talked to Shannon, and we talked to Alan, we said, okay, how long does it really take to run an election? And then I think the answer is probably about 4 months if you're going to do it. So the thought is, if you're less, that's why we chose 6 months, because we thought if it's less than that, you're not going to get any advantage by running a special election. Just run it at the same, it's going to be a special election, but run it at the same time as the general election, because what do you do? Put somebody in like a month before? It really doesn't make that much difference.
But doesn't the 4 months or whatever we think it might take not comport with your 70 days from the day of record?
No. The record date is, we run an election because there's processes in running an election. We have to solicit people to run. We have to have information go out.
He's talking about the operational
The
process.
operational process of it. The voting is only 30 days. That's all we're required to do for 30 days. So
Okay, so there's no implication, I thought there was an implication of the 70 days from the date of record, that was a governing thing for the whole election process.
But there's a lead into the election process, like when we go out to the membership and we say, hey, membership, we want you to get involved.
Right.
They get involved, we set up all the communications, okay, membership, here's your candidates. So we're including that as part of the 4 months, and that's prior to date of record.
What date do you use for the voting number? The people that can record. That's
That's the date of record.
That's the date of record, that's
Right.
right.
No, I totally get what you're saying. I thought that it was I thought that date of record was when the first communication goes out about the election process.
No.
when you determine who's eligible to vote.
Is we're pulling the voter data. The date of record is the date we're
Only
pulling.
those
the
people
voter.
who are eligible to vote on the date of record are allowed to vote.
Yeah, okay.
It's actually 60, the 70 days, my recollection is it came from, that there are 60 days from the date of notice, maximum until you have the meeting. And then since we have a record date that's 10 days before we send out the ballots, that was the 60 plus the 10 that came up.
And no possibility that it should imply going back to the beginning of the process.
In terms, no.
So this one, I kind of have a process question.
Yes.
Lisa, you earlier asked, were we not consistent with the covenants, the statute? This was a biggie.
Yeah. This elect, technically this year, we were more than seven. When was the record date?
December 9th.
Yeah, I mean, somebody wanted to challenge the
Already
election,
got 70
it's
days.
possible. They could challenge all of our elections.
Every election we've had since we started doing technically.
Is that the other
So,
question?
yeah, so the way we're breaking this to 6 months, that kind of sounded logical to me, right? Because you don't want to just be running special elections, but you could have a scenario where you have one of these run as a special election with the regular election, and you've delineated it and treat it differently. And then you could have one where we're running a special election and we don't treat it like a normal election. Right, so you could have two scenarios here, right? So my question is, why wouldn't you if it's separate? That's where I'm trying to get to. So if it's someone left the board in May or whatever happened, right, May. So now we're gonna have to run an election.
You don't have to, could. The board could.
I thought if it was in that 6 months.
The board can, if it's,
Could.
you could, that's the way it's written, is if you want to, you can run, and if you don't, you don't.
Let's say we decided to run it in May, but we're not just running it as a regular election for a person. It still falls under this special election process.
The election basically runs the same way as a general election.
But the voting isn't the same, right?
It's-
A normal election is cumulative voting and quorum, et cetera.
But yeah, we're running it as a separate election. This is where it is a little confusing. We're running it as a separate election because what we didn't want to have happen, and we confirmed this with the lawyers that we can do this, that we didn't want to have happen. For example, if everybody was running at the same time, we're doing a special election and we're doing a general election at the same time. So you got two people running in the general election and you got one person running in the special election. We have cumulative voting. If you don't do them as separate elections, every approved household would get 6 votes, every unapproved would get 3. Could you vote all 6 votes for the person in the special election only? And we didn't think that was the way to handle it.
So I understand that. I got that. I agree with you on that.
Yeah.
That gets a little murky for lack of a.
Yeah.
Especially since the different terms they'll be running, it would be a very complicated, which is why.
But so in May, you don't have that problem. If we had.
Right,
to
if
do
there's
it-
only one director, it doesn't matter. Cumulative voting doesn't
Cumulative voting
matter.
doesn't-
Only one director running. There's the developed lots get 2 and unapproved lots get 1. So cumulative voting doesn't come into play. The reason cumulative voting comes into play is only when there's multiple people running at the same
More
time.
than 2.
Can connect those dots. Okay.
Right.
But
And
then,
the quorum requirements, they're no different for a special election. You still need to make quorum the same way you do for regular.
okay, that's.
Somebody's removed in their last
So you
year.
need
You still need to make, you still.
clear?
I don't think, no, I didn't
Want
think
to
that up.
have a special election before the.
Yeah, we need.
Good, but
We're in a couple.
Hang on, Phil, can we just do one conversation here, please?
This is in a couple of spots, and maybe I'm gonna have to like go back, and think about where it is, where I absolutely lost track of. Voting doesn't matter when it's one, but we still do a quorum.
And it's required by covenant.
Okay, well, I.
Yes.
If you're having a special election in May, it's just. It's Friday. If it takes approximately 4 months to do a special election. So if there's only 6 months left, we're not gonna do it.
Right.
So if you decide in May, it's gonna take 4 months. It's gonna take May, June, July, August to have the election. You're under the 6 months.
No, it's started within 6 months.
6 months before you're
Starting the process.
Right.
So in that situation, if we're looking at May, the board probably is not going to want to have a special
But for, if he's in his last year, I mean, you know, if that spot
Well, and that's
is.
why it's a may. If you don't.
That's
have-
why the board has to analyze that.
That's right, we'll analyze it and. But I would
If
add,
it's- But if it's the last year of that person's term, it'll just be a regular election.
An extra position.
No, if he's gonna fill the unexpired term, no. He'll-
So if you have the election, but if the board decides not to have a special election,
Then
then it's just a regular election.
the next time.
Seat remains vacant until. Just to clarify, other definition of special elections, which is the definitions I'll add, that they're subject to the same requirements as a regular election.
You wrote that it's like, yeah,
Yeah.
but you write, no, like alert, no cumulative voting in special election,
Right,
but I couldn't figure out quorum.
right,
So
right.
wherever you're writing that alert. Yeah.
Okay. You know, I mean, some of this stuff in here is supposed to be directional, and that, I agree with you, that can use some additional
All
clarification.
right, so I think we got that one.
What did we decide on the vote of it?
Yeah, I mean, does anybody think, is it still the 2/3, 3/4, or one more than the majority, the three options?
This is one of the elected director ones, and I wasn't sure why this one would be that.
This is one of the what, Amanda?
The 3/4 are just elected.
Yeah,
It's the
like-
same philosophy. This is the elected directors deciding what, you know, that elected directors should decide what happens with elected directors and not necessarily the developer director. It's the same philosophy.
I understand that is the philosophy. I do not agree with it.
Did
So I kind of think.
And I have no problem. I agree with him. man. I mean, I don't see any reason.
Was this
why.
issue ever
This
brought
is
up with the
very-
lawyers as to whether or not we could limit it to elected members?
Want to say that
Was that
again?
ever brought up to our lawyers?
What?
If we could, in these instances, say just elected directors?
To my knowledge, it is not.
Okay, I think we'll just take it out.
Okay.
What did you say, Brad?
You're gonna let Amanda vote.
Let
It
them
kind
in.
of follows the other one where she's
Yeah,
participating
we don't have any problem.
and she has a view on it.
This is a very,
Well, we're not gonna
This
have
is not gonna
e-members.
happen
We're not
every
gonna have
week.
e-members that long anyway.
it's not gonna happen every week. It's a different issue.
Probably never gonna come up.
No, I don't take it.
But this is not gonna happen every week, so I mean, this is not.
So we'll just make it directors of the,
It's the 2/3 majority plus one.
so I think the next one is 5, 7, 8. This is this is basically what we've always sort of called EVA, action for that. This one is unanimity, and this is because that's the default position in the statute. Unanimity.
In the statute. Is that like 33, 31, 821?
Wow.
You've been studying.
Spent a lot of time on this. I'm telling you.
Really impressed.
I can't wait to throw it in the fireplace.
Wait.
Gotta do the Nancy.
821.
It is. Let me read to you where it is, okay?
I have trouble with hearing.
Well, Brad's got it right now. Let him read it.
She has
I know,
trouble
I have
with
trouble
hearing.
hearing,
She
so I
needs to read
I
it.
need to follow.
So this is, okay, are you there, Beth?
Brad, I have a question on this when we get to the point.
Okay, unless provide otherwise. So this is one where it's the default. Action required or permitted by this chapter to be taken at a board meeting may be taken without a meeting if the action is taken by all members of the board. So it must be an action taken under this section. Yeah, it must be all members.
So the language is interesting.
Yeah.
Yeah, I had trouble.
And we have not, I can't, I don't think we actually ever specifically brought this up with Rosen Haygood, but if you do your own research into it, there's not a lot of case law. And there are questions as to the wording of that provision is confusing as to whether the second sentence is included under the, unless the articles, bylaws, or subsections. It applies to the second sentence. It clearly applies to the first sentence. Question is, does it apply to the second sentence?
Yeah, because the second sentence says each board member must consent.
In writing, right?
In writing.
So it's consenting to the fact that the vote is taken, not consenting to the action.
Right.
And and there are other HOAs, you're not alone in figuring out exactly what that means. Other HOAs in South Carolina have been having an issue with this. From what I've been
I
reading.
think the part that I'm struggling with a little bit, it says, unless the articles of the bylaws provide otherwise. So that led me to think that we could put in the bylaws what we want for this, because it gives us that alternative rather than say the other one that said, this is the minimum.
What we're saying is that this, we believe this is better practice. It's also what I thought the board had agreed to do, was that we weren't going to do e-votes unless everybody agreed. I mean, we set up certain things that we said, unless everybody, and unless it was a time-sensitive matter, which is what we say in here, time-sensitive matter. We said that it's not really controversial and everybody agrees. Otherwise, you just call a vote, you call a meeting. I mean, the other option is not that onerous. You can call a meeting.
So I went back to the minutes because I couldn't remember, and we've had so much debate on this, right? So I was just trying, not that I didn't believe, I was just trying to be sure here. So our minutes say, you gave a brief overview of how the e-vote ratification process works and why we handle some votes in this manner. E-vote is used for things that are not controversial of a timely nature, emergencies, or only if there's an unanimous agreement. But our minutes don't have us ever really voting on that.
We did. We just agreed that that's what we were going to do. It was never a formal vote. One of the problems with not having this unanimous is if the chair, for instance, just sends out an email, we got to vote on this right now, give me your vote. First of all, not everybody checks their emails every 15 minutes, et cetera, et cetera, et cetera. So there's possibility of abuse depending on where the members are, et cetera. Like if somebody's on a cruise somewhere and can't get internet. So you've got to get a response back from every member that, yes, I got the email, let's vote. And otherwise, you got to call a meeting. And then if you call a meeting, obviously you have to notify every board member that there's going to be a meeting. So this is something, because you can call a special meeting, how quickly can you call a special meeting? 3 days. 3 days. Because you can call a special meeting in 3 days. I don't see any reason that, other than something really mundane, that, yeah, you know, Shannon says, look, I got to sign this contract today, blah, 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 blah. Can we get an e-vote on this? Something along those lines. There's no need to have anything but unanimity.
I don't think that required, but I do happen to agree that email is generally in lieu of unanimous consent. I do actually happen to think that that's right. I think if you're going to take an email vote, it should be unanimous. Just
Brad.
good governance on all the boards. I
agree.
Kevin?
I'm sorry, I was trying to get in. I back up Lisa. I think anything that's unanimous or email should be unanimous, but because it's unanimous, I agree with what David said. You should widen it from just not time critical, but anything the board agrees to, because there will be a lot of mundane things, especially with the talk about internal controls. There's more things that we want to sign off on before the KICA staff does. There'll be a lot of things that just get floated around. We sign them, they're done. And if everyone doesn't sign them, they're brought up at the next meeting in person.
There's supposed to be, there should be minutes of the meeting too, that are recorded with the vote in the records.
And we also have to ratify it. We have to ratify it.
I used to see a signed resolution that goes around. It literally is the minutes and the ratification all in, it's not an email, but it's a resolution and everyone agrees to the resolution and it is the form of documentation.
So, Kevin, you're okay with everything except you would take out the time critical aspect of it and just say that it's requires a decision or that an action may be taken without a meeting only if blah, 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 blah.
Yeah, I would start without a meeting. Without a meeting, all directors vote unanimously, they can take action.
Well, and maybe you captured it, but the point I was making is that I think sometimes you go into these e-votes and there is really no minutes of a discussion or how it happened. If it's just vote yes or no and you're done. But for members wanting to know what's behind the decision, you want to have some kind of minutes that's accessible to us as a record.
That's why it's ratified. When it's ratified. Both
I've been to the ratification things. I've seen it say, okay, we ratify the vote and that's it. You just got the action taken.
The problem I have with any time the board wants to do it unanimously, if we're in agreement unanimously, wait till the next meeting unless it's critical to be done now. Because if we start doing anything we want and we all agree and we have an e-vote and there's no discussion in public, okay, it just doesn't fit what we've been talking about this entire day. It should be limited to something that's either very time sensitive, an emergency, or wait, or call a special meeting.
But I agree with Phil's point. So I think, again, when we get to the governance process procedure manual, whatever the hell we call it, we ought to put in a thing that says, and if you're going to do an e-vote, here's the content of the email. It's got to have the rationale. It's got to have the something or other, then it's got to take the vote. So we actually have a record of that. I think that's a great point.
Well, I mean, oftentimes it has. I mean, Shannon's come to us, for example, like on the sandcastle, when we needed to add dehumidifiers. She explained why we needed to have dehumidifiers. And
it was a clear time sensitive issue.
Clearly.
I guess the only.
And that's saved as part of we save electronic votes and we save every one of your emails showing on the KICA email address that you have voted. And here's Amanda's vote, here's Lisa's vote, here's Brad's vote, here's.
Just a nuance on this point. So procedurally, you have this e-vote, which is out there somewhere, and then you come back and you ratify. The only way I, as a member, would know what was discussed at that meeting is if I made a request for the records, because they're not publicly discussed in the ratification process. I'm just saying ratification should be more than just a vote. It should be an explanation.
Well,
I think I answer that.
I agree with you because I
too.
And I think it's in there.
It's in here, but I just.
And there was one where we voted on the bricks, and I said something. I said, well, people need to understand what the bricks mean and why we're doing this. And I did a short explanation, but I agree with you that there should be, and that's why it's in here.
I know we put it in there intentionally, but I just want to highlight the point because it's frustrating.
So here's what I worry a little bit about. Forget about how we vote on this, right? But there is so much going on right now. And there's so much that's going to continue to go on, at least this year, a variety of different things. But there's often not enough time in each of these board meetings to get through the things we need to have, the discussions in public for everybody to hear. And then you go down this path where then it takes longer, it takes longer, it takes longer. I think we need to have the ability to do some things by email. I agree with the Disclosure Act. I agree with improving all of that. But we don't have enough hours in the day in our meetings to have all the discussion that everybody wants us to hear, right? And I think there's going to be times where we're going to need to do stuff over email.
I agree.
This gives the flexibility to do that.
It still should be limited because if it's something that the public is going to want to know what we did and hear our discussion, just call a special meeting. 3 days later, we have the meeting, and that meeting won't be long because it'll be for one item and one item only. We're not talking about putting it off till the next.
But also getting everybody's calendar for a special meeting is difficult. It really is. It's difficult. And if it's, so this is where I think we still have to have the flexibility. I don't disagree with what you're saying. I don't disagree with what everybody said, but I just think, again, from a practical matter, we're gonna have to have some of these because of how many things that we're dealing with lately and getting a calendar. To get just 7 of us together, it's like a 3-week event before we can get everybody in the same room.
Well, if it's a special meeting that's called and certain people are not here on the island, it's going to be for a very specific item, the telephone, Zoom, or whatever. I mean, we've had people in Africa and in New Zealand at meetings, okay? So I don't think that's an issue. It's not a calendar issue. If we're going to vote on an emergency payment of something and we're going to talk about it, call a special meeting 3 days later, we have a discussion and we'll have a quorum. And if there's somebody absolutely can't be there, it's unfortunate, but everybody can get there by telephone these days.
Remember that any director has the option to force that. If it's really mundane, we can all sign it. If one person feels like it needs discussion, they can just not sign and then we'll call the meeting. But I mean, for when Shannon needs something that week, it's very mundane. It seems like it's a practical solution that we're not beholden to.
Well, that's Brad's dehumidifier example.
Right.
Well, that, if somebody had objected to that, we would have had to call a special meeting.
Right.
Yeah, and I agree with that. I mean, Kevin's right on there. Any board member who feels that this is not appropriate for an e-vote can just say, this is inappropriate, we're not doing it. Call a meeting.
Yeah, that's why it's unanimous. Yeah.
Right.
So that one, we don't have any questions. Okay. So I think I understand that one.
Can you just list the act in there so I don't have to?
Okay.
Leaving that unanimous.
Yes. 7,
Are we taking out the concept of time credit or not?
Yeah, well, I don't know. We talked, that went both
I
ways.
think Kevin thinks it's, leave it up to, if somebody objects and you got to kick it to a meeting.
So take out the concept of time.
Yeah, I think that, you take it out and if somebody objects, then that's the way it handles.
And then, but let's put in here that part of the process.
Section 4, this is the removal of an officer.
Article 4, which one are we on?
This is removal of an officer, not removal of a director.
Page 17.
Article what?
Currently drafted elected.
Article 7, section.
Well, I'm in the same place.
So is everybody okay with it? It's either a 1+ majority or 66 or 3/4, and it'd be all directors.
Including the other.
All directors.
Anybody got any objections to that? Okay.
A question. Amanda, I assume you can vote for the slate or not slate, the individual officers at the beginning of the annual at the end of the annual meeting. So,
Right.
okay. So there's parallelism that you can vote for.
If you can vote for, you should be.
That's what I thought. Okay.
Right.
So, all right, that one seemed easy then.
Well, now I know.
Consolidation.
This was taken, this provision was taken, the merger of clerical number, give me a second to look at.
Yeah,
The officer being removed can vote?
under the conflicts, no.
Yeah, well, and again, that is what we need to get to.
Well, the conflict statute's pretty clear, so you get it.
Actually, this provision specifically says not including the director who's being
You
considered.
can vote, but you don't got to consider his vote.
It actually says the person can't vote.
Right, and you can't do that. So we can get to that wherever we get to.
They're
You
back
can't
on
do that. You can't do
article.
that, in my view.
So before you go to mergers, there's another one under committees and task forces.
Okay.
It's Article 8, Section 2.
This one is a unanimous because this is basically going back to the idea that the board is responsible for everything. And if the board wants to delegate its powers, which is what this is essentially it's doing, only the board, all the board can do that, not some subset of the board.
I'm taking out the elected there, that should be.
Right, and since it's unanimous, you may want to then go back to the supermajority, whatever we end up.
Whatever we wind up agreeing.
Although this one, I think maybe actually
Should be unanimous.
unanimous. I mean, don't you want to have the, I mean, are you comfortable? I mean,
I'm fine with that. I mean, I can't see me vetoing.
my view is
In this circumstance.
unless everybody agrees, it shouldn't be delegated, which would include you. I mean,
Well, then we can leave it unanimous.
Yeah.
It should be unanimous.
Delegating something should be,
it's a big deal.
it's a big deal.
Yeah.
So everybody should agree with
It has to be, because you're each giving part of your fiduciary duty away.
Right.
It has to be unanimous.
it. I don't see that coming up very often.
No, I mean, hopefully it doesn't come up.
Well, as long as I'm on the board, I'm not going to unanimously agree to delegate anything, so we can put any names you want.
Take it out.
So, which is merger. Jim, you were going to say on this one?
This provision was carried over from our existing bylaws. This is exactly the way that it is now, so
Right.
it is carried over.
Where do you see like us doing a merger?
Section 5 of these.
Association.
So that one is,
We're leaving mergers as unanimous.
that's what's in our current bylaw. So we didn't actually change that. Article 10, Section 5, bylaw amendments. This one, again, would this be the +1, 3/4, 66?
You know, this is a special meeting, one of them where it's a quorum, right?
Well, the percentage is based on all board members, not the quorum.
Maybe I jumped ahead, I apologize. Any amendments to this section 5 must be approved by members in a special meeting, which would be not cumulative.
Yeah, it's not right. The only place cumulative comes into place is when you're electing more than
That's right,
one member.
right. So, but
Every
this-
other vote is cumulative voting doesn't come into play, and it's subject to quorum,
so
51-0, except,
we need 51% of the people to vote. When you say quorum,
yes.
not a simple vote that said 500 people voted, so it's 251.
That's a referendum, so, and then there are, without getting into, unless you want to, there
No,
are
we can wait.
several other instances in the covenants where there are different quorum requirements. In this case, it would be the 51-0. When I say that, if you don't get quorum the first time, then you hold a second vote and there
I
is no
think
quorum.
you should spell that out
Okay.
because it's not easy to follow, which time it's which. And
I will, like I said, for special elections, I will put in there a provision for all special elections unless the covenants provide otherwise, the quorum will be 51-0. So,
But let's see if we're saying the same thing. I think where we're mentioning some of these, we should be clear.
So I think we've gone through all the ones that require a super majority.
All right, so then on this one, we said 2/3 or 3/4 or the other wording.
Yeah.
Is that what say on this one?
All right, now we're at conflicts. South Carolina Nonprofit Corporation Act has a specific conflict provision. It says at the end specifically that we can add additional provisions on top of this, which is that's why it's phrased the way it is, that we've added additional ones on top. This is an area where there have been, debate. We drafted this one because we were having difficulty with this one, so we asked council to help us on this one. So essentially, it's where you have an interest where it would cause you to have your ability to perform your fiduciary duties would be impacted. And remember, your fiduciary duty is to the entity. It's not to you, it's not to an individual. So that there's a situation which arises which would cause you to not be able to exercise, or at least appear that you're not exercising your fiduciary duty to the entity, then you have a conflict. And then it goes to the board if there's a dispute. The majority of the board would then decide whether there's a conflict. But for example, given the person who has the conflict really couldn't vote, so you'd be down to essentially a six-person board, there could be a situation where it could be 3-3. So in that instance, it goes to lawyer, but we know that that's controversial, who's the lawyer and all that type of thing. The AAA expedited process is probably the quickest and cheapest way we can do it.
Why do you think you need that?
Because you could get a 3-3 split. I mean, that's the problem. You know, if it's a 7-person board or whatever, even if it's a 9-person board, if the person who has the conflict can't vote, that either leaves 8 or 6 left. So it could be 3-3, 4-4. And then what do you do? Hopefully it doesn't come to that, but if it does, I think you have to, I mean, that's what we do kind of as lawyers, is figure out if there's some situation, you know, what do you do in that situation? I hope it doesn't exist.
How long does it take? So that's the other thing. Like, I wasn't clear on timing. So you go to arbitration, if it takes like 4 months, that's a long time.
The expedited one's
What
fast.
do I think about
That
that?
is all done by paper. There's no argument. You should hopefully pick an arbitrator fairly quickly. It's going to depend on the AAA, but generally they're pretty good at that, getting an arbitrator out quickly.
Doesn't AAA also provide that you can pick your own arbitrator?
Yeah,
So you could pick somebody right away.
right. If
Day
everybody
one.
agrees to it, you could say, I want, you know,
Happy Harry.
Jane Doe, you know, I want Jane.
Harry.
Oh, you gotta have happy Harry.
So it would have to be a unanimous agreement on the arbiter.
Probably.
Yeah. I mean, you know, depending on the type of issue we're talking about, it could be something minor. Hey, let's bring so-and-so in here. What do you think? Yeah, oh, fine. You could do it. You could just agree
But I
to
think
it.
you got to provide for how to do that.
It's in- it's in-
With arbitration.
It's in the AAA rules.
It's in the
I mean,
AAA rules.
I get over that.
Yeah.
Don't worry about it.
All right.
Well, real quickly, there's 2 types of conflicts here. The first one is a transactional conflict.
Right.
It's just spelled out in the statute very clearly. And that's, you can't be involved in a transaction. The second one is more nuanced, but it was something we pulled from that I found in other HOAs and different conflict of interest provisions that we thought was necessary.
Yeah, and so this comes back to the point that I think that you can't prevent an elected director from voting. Now, should an elected director who has an apparent conflict of interest recuse him or herself from voting? Yeah, but I don't think you can prevent an elected director from voting.
But then
The statute says it doesn't count.
you can vote.
You can knock yourself out and vote, but it doesn't count.
What, that's how,
The South Carolina
Yeah.
conflict of interest statute.
which one's that?
33, 31, 831.
Unless it's otherwise provided for in the covenants or the bylaws. And I think you can't prevent somebody who's been elected from voting.
No, it doesn't say that, Lisa.
What?
It doesn't say that. It say unless otherwise. This is not one unless otherwise. It says, G is the articles, bylaws, or a resolution of the board may impose requirements on conflict of interest transactions. So this is one where there's a floor, not a.
To me, I think it's the same point. I don't think you can prevent an elected director from voting.
Well, he's not preventing it, the statute is.
And this is a long one. Which?
Okay, go to
Where
the
are you
bottom.
looking at?
If you look at F, it refers to C2. Look at F.
Receives a majority of the votes entitled to be counted under this subsection.
Goes on.
Votes cast are voted under the control of the director as a director in the interest of the transaction, and votes cast by not. So
Not be counted.
May not. Doesn't say shall not, it says may not.
Well, Lisa, if you really want to stand on this hill, if you think that somebody has a conflict, you do it.
Well, so it gets to the discussion that you and I have had over the email with respect to Robert's Rules of Order. And to me, while I don't like Robert's Rules of Order in general, given the weight of it and the requirement or implication for requirement of a parliamentarian and a skilled trained parliamentarian, it is a sort of a generally accepted practice with respect to meeting time. And they're very clear that you can't prevent an elected director from voting. They're also very clear that somebody who has a conflict probably shouldn't vote. The only point I'm making.
Yeah, but you can also put in, if the bylaws have a conflict with Robert's Rule of Order, the bylaws rule. Takes care of everything.
Well, my point on that was we shouldn't be introducing a conflict in the draft, in the rewrite, right? Let's resolve it. I don't think we should be knowingly introducing a conflict between the bylaws and Robert's rules, which we may or may not do. That was my only point there. I certainly understand how you deal with conflict between governing documents.
But that clause eliminates the conflict.
Again, my only point, David, is that I don't see why we would willfully, knowingly introduce a conflict into the rewrite. We clearly at the moment have a conflict in the rewrite.
It's not a conflict if the bylaws, if it says the bylaws supersede Robert's rules. It came up.
I just looked at it.
It's in the director of duties, right? I think.
Yeah, guided by one of those rules.
But it says read before it. I mean, that's what.
It says,
Guided by.
No, but go before that, read before that. Too.
What page are you on?
I'm gonna get there. Director.
Find it first.
Yeah, it's either on page 16 or 17, we'll get there. Keep talking, okay. Lisa, I just want to go, you keep saying elected directors, just, so you're saying Amanda isn't, like, you can exclude Amanda from, if she has.
I know, you're right, Probably shouldn't.
Okay.
No, thank you. Yeah.
I don't want to be the only one getting the brunt of that.
No, totally. Yeah, totally.
Article 5, section 5.
And again, so to me, it comes back to this whole Roberts discussion. I don't know what guided by means.
Well, here, the deleted is, shall be as provided these bylaws, inclusive, and to the extent not addressed in these bylaws, guided by Robert's rules. So the bylaws take precedence, and then if there's something that the bylaws don't decide in terms of procedure, then you're guided by Robert's rules. So in other words, somebody can't, I think we chose a language, and maybe we may disagree on this, but.
Yeah, I said guided. That was,
Okay,
I said that was for Todd's.
I think there's a distinction when you say guided by. Does that?
Oh my God, but.
And what does guided mean?
Well, before it said, to the extent not subject to.
Right.
And guided by, subject to means that you have to do it. Guided by means that you look at it and try to get the sense of what it would give you in terms of how you should conduct yourself.
This was to address Kevin's concern, because he actually participated in the meeting that we had, and he was
I
concerned.
understand your concern.
I hear you, and I still think that guided by, so if the bylaws are this big, Roberts is this big, so there's a boatload of stuff.
Yeah. So what happens if the bylaws don't give you guidance on how to act?
You got 757 pages.
Or are we back on conflict of interest?
Well, I guess.
Sorry, I diverted.
Yeah, I think you guys went a little farther than what I had talked about on Monday.
Well, I couldn't understand.
Say it again, Kevin?
Didn't go far enough.
Oh, I'm sorry, you went a little bit farther than I went on Monday. I ultimately think it should be driven by the chair. What we were trying to do is put something in that said the chair would, wouldn't make up his own rules, but he would be guided by, we put this in here to the extent not addressed in the bylaws. But I don't know if there's a good way to state it, but we want to follow a normal decorum and we will use motions, but ultimately it's the chair that's got to direct, because to Lisa's point, if we put anything in like Robert's rules, we've by incorporation built in hundreds of pages of documentation.
But it is, I mean, but Kevin, we're all subject to hundreds of pages of things for everything you do. I mean, you're subject to, 60 pages of state statute and things like that. I mean, I'm concerned about saying it's hundreds of pages. I mean, Robert's rules actually is required in a number of states that HOAs follow.
And other HOAs have used it. My issue that I raised was that, look, I've been on lots of boards that are subject to Robert's rules. You don't follow all 900, 800, whatever pages of it. There's certain things when there's an issue, not affecting the area, if the chair doesn't operate the meeting correctly and you have a dispute, you can look for it and find it. And that's why when we discussed it, I thought Kevin was in agreement with using guided by, because then it allowed you to just, look at it and find out how to resolve the issue.
Yeah, I think to the extent not addressed, I think my original language was in the spirit of, but I think I ultimately fall back that we can try to give the chair some intent, but if it comes down to it and there's a battle, because these documents are all about battles, the chair wins in the battle. It was only meant to be guidance or a spirit and not a binding, and no member or director could hold up the board at a great length trying to go in particular into the Robert's Rules of Order.
My opinion, and I'm not versed in Robert's rules like all of you are. I think with the new bylaws, and once we get agreement on the supplemental, the governance procedures, we have a lot of stuff in there now to make sure our meetings run well, make sure people are following the right motions. These are good documents that can help educate people, because we had gaps on who knew what about how to run a meeting and what to do. We have a lot there. And I think we can be successful with what's here and with all the stuff you guys have done to help.
They're there in case you have a dispute. And the question is here is if there's a dispute over how something is to be run, then you can go and look at it. I mean, if everybody, it's a fallback position.
Why wouldn't we have so much in here now? What would we not have in here about how to run a meeting, how to conduct a meeting, how to behave in a meeting? All the order of things, you guys have really fleshed that out.
It belts and suspenders, in case you have something that is not in our bylaws, you're guided by that. And the board can say, we're guided by it. There's a short version of Robert's Rules of Order.
347 pages.
Whatever it is. And you get in there and then you look it up and you go, it says you should do it this way. Okay, and the board can sit there and go, yeah, let's go with that. I mean, or the chair can go, let's go with that. That's what it says. We're not obligated, so therefore we're not stuck with it. But I think if something rare comes up, that we got to be guided by Robert's Rule of Order and get to the thing that addresses that, which is not going to take that long. And you go, this is the way it should be handled. Everybody in agreement, fine. If we're not in consensus, well, then we got another problem. I don't see it as that big of a deal to use the word guided. It's guided is using the law a lot.
I think we should parking lot Robert's rules. I don't think we're going to get through it today. I don't think we're all even close to the same page on this one. I mean, we just come back to it as we're whittling down all the issues.
Interesting, Hilton, so not that we want to be like Hilton in other ways, but the model we used, section 5, Robert's Rules of Orders, any meeting of the members and or board of directors shall be held in accordance with the then existing current edition of Robert's Rules of Orders. Shannon, you said you know the, do you want to maybe see how that works down there, how they actually in practice? Maybe that gives some guidance, yeah.
But this is one that it's not statutory law in South Carolina.
But it is.
It is in the states, yeah.
It is best practice.
But it is in other states. No, you don't have to do it.
You don't have to. let's be honest, South Carolina isn't exactly on the cutting edge of.
Well, you can pick and choose when you want it, when you don't.
It's like something we want to,
We have 15 minutes. I don't know. Most of the time.
finish the conflict of interest page, Brad.
Oh, did we define what a conflict of interest
Yeah,
is?
it's all defined in here.
It's all defined.
The top of page 11, the rewrite, not the red line.
Yeah, I don't have the red line. So what do you?
Well, conflict of interest, there's a sentence that just doesn't make any sense. Yeah, it says if, at least it doesn't make sense to me, I'll clarify that. If a majority of the directors on the board who have no financial or personal interest in the transaction vote to authorize, approve, or ratify the transaction, a quorum is present for the purpose of taking action under this section. I mean, if, what is this, is it saying it's just about the quorum? I had trouble with this sentence. You can look at it, you don't have to.
Yeah, I see what you're saying. I think we just need to clean that up.
It was like, it's like there's something missing. I was reading it like, okay, then what happens? You can just take that as a,
There's no second right at the statute, so I'll go back and look at it.
Yeah, we'll just look at that and clean it.
Present.
Yeah, it should be two different things.
something's weird.
Any other thing in conflict before we move on?
Did we decide about the director voting or not voting?
I'm just reflecting back on this for 1 second. What it's saying is that, let's say you have 2 or 3 board members that have a transaction conflict for some reason. So you're left with 4 board members who can vote. That is considered a quorum. Without-
Yeah, as written, it's a little, but it's right as written, given the intent.
Right.
It's saying for voting purposes,
Right.
you got a quorum.
Whoever's left on the,
Constitutes a quorum. Yeah. It could be cleaned up, but it's right.
Carol?
Question, do all the board members know each other's conflicts from your statement so that you would know who can and can't vote on an issue? So how do you
Not really.
determine that?
Well, you don't know until an issue comes up, whether you have a conflict.
It raises an interesting question is that should the conflict of interest forms that we all filled out be circulated amongst the board so everybody sees what they say?
Well, the conflict of interest statement states that you should disclose if you have a conflict. Okay, you should disclose it.
We disclose it on the form, but we don't see the forms.
So that's at the discretion of the board member thinking, oh yeah, that might be a conflict. It's an honor system thing.
You can interpret it that it's on the form, but that you should disclose it. That should let people know, not undisclose it on the form. You should make people, because if you only sign it and you keep it to yourself, that's not disclosure.
But I think this is me talking, and it's not going to be me going forward, but a better practice, I think, is that all those forms get circulated.
Oh, I agree. I have no problem with that.
So that everybody knows
But-
what's been disclosed.
I mean, you don't sign the form and keep it secret. I mean, that's not the purpose of it. Just disclose it.
Yeah, but the problem is.
I'm just saying, they're not kept secret, they're filed in HR,
We can't-
but we can't see them.
So you, as other board members, don't know if somebody really has a conflict and they still voted on the issue. Okay.
Or what they even.
So Shannon knows all the conflicts, not.
Yeah, she remembers them all the time.
Yeah, I don't.
I know, but that's.
All right, these last ones I think are pretty easy, because on and off. Board member, there's been talk about that.
Slide.
Oh, governance board model, okay.
Yeah.
Here you go.
We decided that these bylaws are kind of a how-to manual, and this is really, we thought would be a policy that's adopted by the board, policies adopted by the board. One concern is that, that they can be used to silence community members or preclude board. There are lawyers out there who have written that particularly these policies for code of conduct of board members may actually be unenforceable because they may preclude a board member from exercising or his fiduciary duty. So you got to be careful about this. But we didn't think this was appropriate in the bylaws. The board, if they want to do this, they need to talk about it, but I would also strongly recommend that you talk to a lawyer about it to make sure that you think it's legal. Yeah.
Well, and as someone who practiced First Amendment law for many, many years, if you want to put a member code of conduct in place, you're going to have a real problem. So be very careful with that.
It's always saying that somebody can't speak is a big deal. And that's essentially what these do at times, or can't even ask a question. And that's where it does impact your fiduciary duty. If you can't ask questions under certain circumstances, and the majority of the board, because that's the way most of them are, the majority of the board decides that that's inappropriate, then you can't exercise your fiduciary duty. Sometimes you have to ask questions.
I don't think it's, at least where I'm sitting on this, it's not saying, and maybe there's a different way we go about this, but it's not saying that you can't ask a question or a board member can't ask a question. It's always about how is the question asked, it's the behavior side of it. It's not the First Amendment right of asking a question.
Let's take an example. Suppose you ask a question and you don't get the answer, and you keep asking the question. And we've had this. You keep asking the question and somebody gets frustrated and they write something or they get angry and you say, oh, can't get angry. That's a problem. And so, you know, it becomes a real issue that you need to be careful about it.
So I take the other side of that, okay, I granted people can get frustrated and they can get angry, but they should not be expressing their anger in a crowd with other people that can take it a different way. I just think that's not what we're supposed to be doing. We're supposed to be able to be talking in a civil manner to each other, understanding each other, working through our differences without raising our voices, without having anger.
I agree with you. That's the way it should be.
And that's the way we need to get
But
it.
that meeting that we had when we expanded the board and appointed 2 members at a meeting that wasn't even a meeting, there was no way you were going to keep that meeting calm.
Okay, so let's go forward, right? We've got all these.
We gotta learn from the past feedback.
We've got all these new bylaws and new rules and talking about how we're supposed to operate. I would be hopeful that we're not going to run into those kinds of situations anymore. That we're going to all learn to operate the right way, the legal way, take the high road, like Brad is saying, on things that are legal, like maybe it's not required, but that's still a better way for us to be. You take the high road, and having people that we are all dealing with, having to communicate to each other in a way that is civil and respectful and not argumentative, that we can get through it, is only a good thing.
That's a pretty good guideline.
Oh, yeah, basically your fiduciary duties.
There's a lot of documents that we've got that.
Yeah, I mean, I still have that, Jerry. I mean, because actually I was giving somebody else's really, but I was.
I think it's a good guidepost and something that, you know, as someone who has risen in anger and pounded my fist, I regret those things. I really do. I would call myself out of some of my behaviors. And I would hope that what we're doing here, the discussion like we're having today, is civil and respectful. And if we can maintain that tone, which I believe we'll be able to do, I think we'll all be in a much better place.
I don't want to live through another year. You know, we've had so many years of everybody fighting and bickering and yelling and this and that, and I don't want to live through a 3rd year of that. I am really talking about
The way we can prevent that, okay, and I've been on the board for 4 years. Our votes are either 7-0 or 4-3. Okay, and the 4-3 is the same 4 and the same 3. And stuff has been crammed through because we know the vote's 4-3 before we even get into the meeting, because the motion wouldn't even be made unless they already knew it was 4-3. That's one of the problems that has resulted in people raising their voices and pounding the table or whatever. Okay, and it's just, I brought it up with the previous chair. No polling by the chair to the rest of the board members prior to a meeting unless you poll every member of the board, okay? And that's, in my opinion, it still happens because you walk into a meeting and a motion's coming up that's controversial, you'll already know it's 4-3. It's been that way for 4 years. I've been there.
Well, I'm not getting off this one. I can tell you, this is a sticking one.
I'm totally opposed to a board by conduct, whatever you want to call it, statement or whatever.
Code of conduct.
I mean, it's an attempt to, quiet us down or shut us up. That's basically, that's all an attempt. That's what it's trying to do. I have.
It's not.
Can I speak? I mean,
Sorry.
I'll let you speak.
The deaf side, I thought you.
I mean, okay, I'm totally opposed. I think it's only an attempt to, quiet people down. I represent my members. I don't represent the board. Okay, I'm going to let my members determine my conduct, not the board. They will determine. How do they determine it? At election time. Dave DeStefano got reelected. They said, "Hey, you got good conduct." That's how code of conduct should be represented. Okay. Now I have no problem with an ethical list of conduct. Yeah, unethical. Yes, let's list an items of what it's unethical to do. Let's do that. Violating the financial control manual, excess. Let's do that. Not the conduct of a board member that speaks up to represent its members, the people that elected you. Okay. I'm not here representing our board. I'm right here representing my members. Okay, let them decide what my conduct is.
Merrill, you had something you wanted to say. I'm cutting you off a little bit, Alex.
That's fine.
We're trying to finish.
I was finished.
You only have
I was
20
finished. I was finished.
Just going along with that, I think from sitting here, to know why the vote, when it is a 4-3, I want to hear from everybody to know why. And that's what we don't get from sitting here.
That's not proper conduct.
On
That's
code
right.
of conduct, my understanding is Seabrook has recently passed these. I think other HOAs have them. Let's do the research.
Well, I looked for some and looked at some of them, and the problem we were having is what Brad was saying, and Maura pointed to. It's code of conduct can be very, it's very misinterpreted as to what you can do. I mean, you have to have respect for each other. There's general guidelines that the board should be following in dealing with each other and dealing with the members that are in the room. And I was there in that last meeting, and there was some disrespect coming from the members towards the board. How you control that and how you handle that is what we're trying to figure out, but it's impossible. I had this person in one of my enforcement cases, and he was just screaming and yelling at us. And I said, "You don't need to yell and scream." He goes, "I'm not screaming, I'm just loud."
I'm just passionate.
And it was passionate as all get out because it was very important to him. But how do you write that? How do you articulate that so that it controls people's behavior?
My only comment on that, I think that's what we would have to look at, but passionate to you, to me, it's how the person takes it. It's not the person saying and giving it, it's the person receiving it and the perception that I have from that interaction. It's not just one-sided. You can be passionate, but if your impact on me is so negative, that's a problem.
I think we need to take it up.
How about when you withhold documents from a board member? You don't think that impacts you? That impacts me when you withhold documents.
Alex, we're not going to go into that territory.
Todd has something to say.
Yeah,
Well,
please.
before we close, I had two things that I wanted the board to think about. I apologize.
No, go ahead.
Yeah, so the first thing is in Article 10, inspection of records. We've broadened, the what you can do for beyond things that are privileged information, and we can follow up as why I can think of case things. Work I did, we had case law we refer to, we had best practices. and boards, things like that. So, my question would be, do we really want to expand beyond, privilege information? The other thing, and with regard to the identification, I'll follow up from maybe, but I think you have to think about what you've written. I don't know how much of this is statutory action, but putting my CFO hat on, and you have to think about your role individually versus the board. When we say that we cover counsel expense, if the board gets sued, does that mean 7 lawyers that we're agreeing to reimburse? What if the board chooses to have a single lawyer representing? So again, I think you have to separate your role as an individual versus what you're trying to accomplish as a board. And the other thing is, I'm used to having the indemnification limited. It may be there to the committee, to things that are proper actions. And since we're now expanding it, which I think is good, from the board all the way down to task force members. If we have a task force member who does something that's beyond their authority and they thought it was an action being taken in good faith, the question would be, do you want to have to indemnify them for that? You may choose to, but the way this is, I think, is written, there would be an argument that if they thought they had the authority and they exceeded their authority, and I'm moving here from directors and officers more to committee members and task force members, I think you're obligated under this language to indemnify them. So, okay, thank you.
Brad, we can.
The last one is the ELB. We had, that's a hot button issue, and originally put some things in there. But obviously, the board needs to address it. And I just know that Toki is moving forward, and if there's going to be further discussion.
Everybody see the revised language on that? We took out the one, okay. And everybody, you're okay with the revised language?
Can I close by saying what a great job you've done. You've been thoughtful. Even though we may have some disagreements or some questions we want to question, I think overall the thought and the care that has gone into this is obvious and gives us some points to debate. But I think we'll be able to get to a good solution and have a vote on this, and I think it will have been a great service to the community.
So what are the next
So
steps?
we have to.
I know Kevin and I still have unanswered questions and things we didn't get to. So what are your next steps here?
Have a next meeting.
What are the, maybe just summarize what you put in an email to us, what's left.
Well, I think some of mine are going to be, I benefit more from a discussion.
And some of it is, we talked about it today. We were generally in agreement, but, I don't consider, my point cleared until we see the language is all.
Which particular point, Kevin, or all?
All of them. I just, until we see another draft and you can see the language, I don't check it off my list. So it's not necessarily that it may be, I don't think we got through unanimous 66-75 in most cases. I think you're going to repropose something, but I don't know that it's in final form or even close to it at this point.
Brad, do you think you'd like to have another meeting like this in which we review then the things that have been?
If you want. It should be fairly shorter, much shorter, hopefully, because we.
Oh, no, it would be much shorter, but I
Yeah.
think we have a chance to talk about some of these things.
If anyone wants to meet, or task force wants to meet, and then we'll come back to you with a revised draft.
That'd be great.
At some point in time, we just got to have a board vote.
Right.
I just want to get.
I would hope by the
I want to get through the rest of the things that I either don't
Ready to go on.
understand or have questions on.
Do you mind, could you just pick them out and send an email as to what we.
If I have to say meeting adjourned, I'm going to the discussion can continue.
There's a couple that I need